Recording has begun. Good evening. This is the February 5, 2025 regular meeting of the Sunshine Ordinance Task Force. The time is 4:14 p.m. The Sunshine Ordinance Task Force and its committees convene hybrid meetings that allow in-person attendance, in-person public comment, remote access for petitioners and respondents, and remote public comment via teleconferencing. Members of the public may participate by phone or submit their comments by email to sotf@sfgov.org. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to the disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Chair Yankee, that concludes my comments.
Okay, let's move on to item number 1, and if you can call the roll.
Calling the roll call. Member Schmidt.
Present.
Member Schmidt, present. Member LaHood.
Present.
Member LaHood, present. Member Sugarman.
Present.
Member Sugarman, present. Member Kumar. Member Kumar, absent. Member Anderson.
Present.
Member Anderson, present. Member Highland.
Present.
Member Highland, present. Member Pilpal.
Present.
Member Pilpal, present. Member Wolf.
Present.
Member Wolf, present. Vice Chair Stein. Vice Chair Stein, present. Chair Yankee.
Present.
Chair Yankee, present. 1 absent, 9 present.
Okay, so we have quorum. Do we have any agenda changes?
We have no known agenda changes.
Member LaHood?
I'm noticing on the agenda, and I want to see if I'm doing something incorrectly. I can't click on the administrator's report.
From the agenda,
That's correct.
is the agenda downloaded or are you viewing it?
I'm looking at a PDF, or I'm viewing it. Do I need to download it?
Yes, please.
Okay, thank you.
I'm looking at the live one on the website, and I'm having the same issue as you. There's no link. In the attachments, it's typically underlined in blue is not underlined in blue. And for the record, 419, Member Kumar arrived. This one here. This is the one I.
Member Highland says it works for him. No. Administrator's report.
And I did the driveway. That's just one thing I haven't tested yet. I didn't want them to go down.
Right.
Can't be linked here. Skip it.
So we're just gonna
That's changed.
probably have to continue here. With it?
Member Kumar.
No, 490. Remember, Highland, did you able?
No, I was looking at another item.
Okay, so I don't think anyone can use it. So
Which one?
Just have to continue it.
administrators report attachment.
Member Highland, I recommend we probably just continue that item then, since we can't.
Okay, so moved by Member Highland to continue item number 3. Is there a second to that?
Second.
Seconded by Member Anderson. I don't see any other hands. Is there any public comment on that particular motion?
Sorry, I did not hear the motion. What was the motion?
This is the motion to continue item number 3. That's because the attachments link on the online version of the agenda does not work.
Member of the task force can't see it.
So I'm Peter Warfield, and I have a very serious problem with item 4.
But we're not on that. We're just on the motion for, I'll do another public comment for anything that's not this motion. This is just the motion to continue item number 3.
I would like to comment on item 1. Will I get a chance to
Yes,
do that?
I'll do another, reopen public comment for anything that's not the motion.
For item 1.
Yes.
Thank you.
So this is just the motion to continue item number 3.
Moved by Member Highland, seconded by Member Anderson to continue item 3, Administrator's Report. Because
Member
the
Philpott?
link in the agenda is not attached.
I have no objection. I will support the motion. I had a couple of thoughts and questions. I think I can work them into whatever it is, item 11 at the end.
Okay.
It's not something that's going to change the world.
Okay.
That's fine.
Sorry, I didn't mean to cause a disruption with that.
No, I'm glad you did.
Well, I was going to say, since the items are listed on there, if any, maybe there's a reason to keep those on there in case there's anything urgent related to them, since they are listed on the agenda, even, we can't have the
Discussion on the material report, we could still discuss.
we could still discuss if there's any scheduling
good
issues
point.
coming up or things
Yeah.
like that.
And
So,
in fact,
Yeah.
yeah.
Member Highland, you made the motion to continue. Should we, I don't know if you heard what Member LaHood said. I did not. No.
I was suggesting, even though we can't discuss the underlying documents, since these items are listed here, and if there are any issues regarding, I don't know if anybody has an attendance issue or if there are scheduling issues, that maybe we should keep it on there to be able to have that discussion, even though we're not going to discuss the underlying documents.
Member Highland withdraws his motion.
Okay, is that okay with the seconder?
Or,
Yes, it is.
Okay.
or Mr. Chair?
Yeah.
Before those go away, maybe if we just defer action on this, have a brief discussion, and then consider continuing the rest of the thing to the next meeting?
Yeah, we can talk,
Whatever.
we'll keep it on the agenda. When we get to it, we'll get to it. So we're just not going to
That works.
pre-cancel. Okay. All right. So any other agenda changes besides that? Okay, not seen any. Now I'll take public comment on item number 1 in general agenda changes. 3 minutes.
Your 3 minutes begins now.
Peter Warfield, Executive Director, Library Users Association, Library Users 2004 at yahoo.com, and P.O. Box 170544, San Francisco, California, 94117-0544. I think you should not have number 4 on the agenda, or at least not take any final action, because all of the documents that I went to the clerk's office to look at had problems with the link. So the annual report link came up with unauthorized error number 401. That's the Google Docs. The survey, same thing. The complaint resolution, same thing. And the next request was even worse. That one said, sign in to continue to go to Google Drive. And for that, they demanded to know email or phone number, which in fact, neither I nor somebody who helped me in the clerk's office was willing to provide. There should be no requirement to give information to Google, to a profit-making outside company, in order to see a public document. The only way that ultimately I was able to get something was on the annual report item. It said, prefer not to use the link, see 2024 annual report as a PDF here. And there I got an annual report, which is also problematic. First of all, it does not include all of the items that are listed as part of the annual report. In particular, does not seem to have the so-called next request general, the 2024 next request general that I see on page 3. Furthermore, the version that I got today has 34 pages, which I showed to the your folks here and chair included, while the one in the book here has 33 pages. So that led to a bit of a discussion beforehand, because I wanted to alert folks that there were only minor changes, this, that, and the other thing that I could obtain from the writer Laurestein versions 2 and 3. I didn't know there were other versions and so on and so forth. That was another issue. Basically, this has not been provided to the public in a way that it can access what you are going to be discussing and presumably acting on. I don't think it would be appropriate to go ahead with that item, and certainly not any kind of an approval of this draft report. Thank you.
Thank you.
Okay, do we have any other public comments on item number 1? Anyone online?
If there's anyone online who would like to make public comment on item 1, please raise your hand using the app or press *3 on your telephone. If there's anyone in the room who would like to make public comment on item 1, please approach the podium. I'll give you a moment. We have no one in the room and no one online.
Okay, we'll go ahead and close public comment and move on to item number 2. Sorry, did you have something?
Just very briefly, thinking about what the public comment we just received, but we'll deal with that when we get to item 4. I don't believe I've met the deputy city attorney. If he could just identify himself so that we know. I'm not sure if this is your first time here, perhaps, or not.
Hi, my name is Adam Shapiro.
Got it. Thank you.
I'm sorry, Mr. Chair, I did not hear that.
That other microphone.
He's going to repeat it.
Adam Shapiro, Deputy City Attorney.
Did you hear that?
Good to meet you.
There we go. Thank you very much.
Okay, let's move on to item number 2.
Item number 2, approval of orders of determination. Item file 23099, Mark LaCroix against the San Francisco Fire Commission. And file 24056, Michael Petrellis against Andrea Aiello, Executive Director, and the Castro Community Benefit District.
Member Pilpel.
So a few issues here, and I will keep it brief. On 23099, I believe we previously issued an order on the initial complaint about the meeting violation. I believe it was under the same file number. So I have no problem issuing a new order here, but perhaps if we labeled it as 23099B or somehow distinguished it so it should supplement the prior order, because this is on the records aspect and should not replace or have anyone believe that somehow it replaces the prior order. That's on the LaCroix matter. I also suggested rewording the action so that in both cases, at the end, it would read an order production of the audio tape of the closed session on item 5C at the January 12th, 2022 Fire Commission meeting. The rest of it is not so important. On the second matter, the Petrellis matter, our prior practice has been that when we don't rule on the merits, that we generally don't issue an order. If there's a good reason to have one in this case, I have no objection to doing so. I now can't remember which committee because I was at 2 meetings last week, but at one of those we heard a different complaint from Mr. Petrellis, and under rather similar circumstances without Mr. Petrellis being present, we found no jurisdiction in the matter at this time and effectively killed it in committee without bringing it to the full task force. And the logic was remarkably similar. If we shouldn't have done that, that's fine. We can go back and fix it somehow. But I'm just looking for a brief dialogue on whether we should have an order if we didn't reach the merits here. If there's good reason, then yes, let's do that. And the other, and there were some minor typo things here. It should be admin code chapter 12L and not section. But those were my comments on the orders. And other than that, I'm happy to move approval as discussed, with edits as discussed, and submitting these in writing.
Okay, do we have any comments on Member Pilbell brought up?
Yeah, actually, I think it's an important thing to discuss, and actually, I'm curious with Vice Chair Stein. In fact, in some of the things that I was reading with the annual report, I always assumed that order of determination meant a finding of violation, and if it's not a finding of violation, then maybe it shouldn't be an order of determination, unless I am wrong, which I can accept. But I want to make sure that we are all on the same page with this.
Mr. Chair.
Go ahead, Member Wolf.
Yeah, my sensibility about this is any decision that the task force takes is an order of determination, whether it's a violation or not. That's our ultimate decision in the end.
Member Highland here, and since Member Pilpel brought this up, I think typically we refer it to the full task force with a finding of no jurisdiction. That's how we've handled most cases. However, just because we've done it that way doesn't mean, or is it possible for a subcommittee to do what we did, which was find no jurisdiction and dismiss without prejudice, basically at that point, and not send it to the full task force? I would think we have that authority, but we've never exercised it. And I think that's what we did at the last meeting. And that's something we can talk about in, a separate rules discussion, whatever, but that's what's kind of coming out of this for me. Right.
Yeah.
I don't know if you want to.
Yeah, I'll make a few comments then. First one, I can't find a posted order of determination for the, we'll call it version A of 23099. Pat, I don't know if you just didn't post it on the website or if we really did issue or not issue an order for 23099. But Member Pilpel brings up a good point. This is like a separate, one. So if we do have one and you just haven't gotten to posting online yet, then we should, I think, label it A and B. I think that's a great suggestion. Okay. As far as the second issue brought up, I think that if we're making some type of decision on the merits, be it whether or not there's jurisdiction or the actual violation, I think it's helpful to have the order of determination. Whether or not it's required, I don't know. But I think at least if anyone, including us, were to go back and try to research past precedent, it's easier to find things listed under orders of determination than it is to try to search meeting minutes. So I certainly don't think it hurts to have an OD on what we decided. And then I'm looking at our bylaws about what committees can do. So I'm just going to read the complaint one, but the language is essentially the same for all of them. It says the complaint committee shall monitor the complaint process and make recommendations to the task force regarding how complaints should be handled. That's just the general catch-all what they do. And it says the complaint committee shall schedule priority review of 6721 claims, including where appropriate determinations and orders in hearings on complaints. Okay. Shall schedule priority review for 6721 claims, including where appropriate I think that language is a little off, but I think it's saying appropriate determination orders. And then separately it says, and here have hearings on complaints to review jurisdiction and the merits of the complaints in order to provide recommendations to the full task force. So that seems to me that they're making recommendations ultimately, be it for a full hearing or through the consent calendar on both jurisdiction and merits. That's how I'm reading the bylaws. So I think in that case, it should go to the full task force to make the final determination on that. And it could be through consent, and that's fine. Right. Okay. All right. But in this case, I thought, remember, Pelpel said the petitioner didn't show up, so that may be a separate reason that you closed it that has nothing to do with this.
Yeah, I think that's we ended up closing it for 7B.
Yeah, which is fine. That is fine. Yeah, committees can certainly do that. That's an administrative closure, not ruling on any type of merits.
Okay. But we are guided that in the future, if the petitioner is present, that we should make a recommendation to the full task force and not.
Because I think, some of those are kind of gray areas and they may have different opinions as a full task force. And I think that's a good thing to come.
An order of determination is essentially an action, which
Yeah.
should be by the full committee.
Yeah. I think the only time we don't use orders of determination is when it's administrative closure, like a 7B closure, and there's no need for that.
Okay, so I can accept that. So to be clear, just because there's an order of determination does not mean there's a finding of violation.
Yes.
Thank you.
And historically, I've gone through and looked back, 10, 15 years ago, and we've had ODs that show not or no violation or a violation, either side of it. Okay. So I think there's a motion by member Pelpel then to approve with the edits that we just discussed.
Yep.
Those two ODs. Is there a second to that motion or any other comments?
Member Highland seconds.
Okay, seconded by member Highland. Let's go ahead and take public comment on that motion.
Anyone wishing to make public comment on item 2, please approach the podium if you're in the room. If you're online, please raise your hand using the app or press *3. We have no one approaching the podium, no callers online.
Okay, we'll close public comment and take the roll on that motion.
Taking the vote, member Pilpel.
Aye.
Member Pilpel, aye. Member Highland.
Aye.
Member Highland, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 10 ayes.
Okay, let's go to item number 3.
Item number 3, Administrators Report. Task Force and Committee Tentative Hearing Schedule with potential adjustments. Complaints and hearing requests. Sunshine Ordinance Task Force member attendance. Sunshine Ordinance Task Force member training requirements and communications. I want to note that the attached administrator's report is not attached.
So we can't discuss the report itself, but there are bullet points of topics we can discuss if anyone feels the need to do that. So I'll just open it up. Does anyone have any comments on any of these bullet points? Member Papa?
I think member Kumar was first.
Juke, I'm sorry, didn't see you over there. Go ahead.
Yeah, so my in the last EOTC meeting, we had discussed, I had informed Chair Highland and Member Pilpel that I won't be able to attend the March 25th EOTC meeting as I'm unavailable that week. So is it possible for us to, swap that meeting with the March 18 meeting of the complaint committee?
I'm sorry, could you repeat that?
Is it possible to swap that meeting with the complaint committee's meeting on March 18 if the complaint committee is okay with that?
This was what we discussed at the EOT meeting last week. Is it clear?
I would caution against doing that, and I'll tell you why. With complaints being 2 weeks prior, typically 2 to 3 weeks prior to the full agenda, if they take any action on complaints, which are typically the 6721 ones, I can get that. Gives me time to put them on the agenda for the upcoming one. If it's the last week of the month, anything that they rule on will not be able to go for another, till the following month, right? So if it's end of March, anything that the complaints committee rules on won't appear until at the earliest is May.
So,
but if we keep it as is in March, then I can get it on in April.
so here is the thing. I believe Chair Highland and I are able to attend either on the 18th or the 25th of March. Member Kumar was unable to attend on March 25th. What we suggested was swapping the dates, and I believe we also suggested that if there was anything that had a timeliness concern, that we would be willing to hear that in the complaint capacity, and that any that could wait a week to the 25th, the complaint committee would hear in their normal capacity, so that this meeting in March of EOT included all three of us and not just 2 out of 3. We did not want to lose member Kumar, and so we asked Pat to check with Chair Schmidt and the complaint committee to see if they could accomplish the swap, understand it, not wanting to delay anything to May in the way that you talked about.
Okay. I'll defer to everyone on the complaint committee. What do you folks think?
I'm fine with it. Members of the committee, what do you think? Any objection to that calendar-wise?
I have no scheduling conflict, so I'm okay with that for March 18th. Yeah.
Oh, okay. Yeah, sounds good.
Okay, sounds like everyone's in agreement. So what we'll do is we'll swap the EOT and complaints in March. Just flip-flop them.
Thank you so much.
And then make sure, Pat, that when you work with Chair Hyland on that, that you get anything that's time sensitive on the EOT agenda. That's the one thing I just want to make sure doesn't.
Probably schedule those things first and whatever we got to do. We were trying to exhibit a little creativity there.
Yep, that works.
Great. On other aspects of the administrator's report, without going into the details, because I understand the attachment wasn't available for some people. For next time, could we maybe have a little blurb on each of the, since there aren't that many, each of the pending 2021, 22, and 23 matters, so that wherever they are in the process, if it's complainant didn't want hearing scheduled or whatever the follow-up thing is, I'm just hoping that as soon as possible we can dispense with those matters. There are only 8 according to this. Anyway, I'm just looking for like a sentence, no, not more than 2 sentences on each, so that we can be a little better informed. I'm not asking for the full complaint chart. I'm just trying to deal with the cobwebs.
Pat, is that something you could do? Anything that's kind of let's say over a year old, can you list out and say why it's still hasn't been heard?
Where it's at, what's up with it?
I mean, the general, go ahead. I'll go with, I was going to say the general answer is I think the majority of those are from one particular petitioner who for a long time didn't want to have his hearings heard. We're going to start, I think I mentioned that last time, Mr. Carnazes. I think that's probably 6-ish of them. Another one is the one we talked about last time with getting the DCA's advice. I know Member Hood's going to work with the DCA. I'm not sure if there's any others, but if you could list those out on the next admin report, anything that's.
So that is the publicly shared, because in the agendas that I circulate to the committee members, and it's not in a group so that there is no sunshine violation with group communications, but in that copy that I circulate, it has specific comments on each case. So the request now is to include those comments on the published?
No. What Member Pilpel is asking is that there's apparently some files, I don't want to get too much into what's in the written report, but anything that's, we'll just say generally.
Pre-2024.
And anything that's a file from 2023 or earlier, right? So file number starts with 23 or 2221. We're pretty much caught up with the backlog. So he's asking if there's anything that's 23, 22, 21 or earlier, why that still is outstanding. You just put 23004, petitioner was waiting to schedule, or 23005, waiting for DCA opinion, just something to show why those haven't made it through the process yet.
I can do that. Currently, the comments reflect all cases beyond 2023. I can.
No, just the old ones. Just the ones.
Now switch it and
No,
present information only on the old one.
For the administrator's report, I'm just asking for this little blurb on those really old or relatively old things. You can continue to track whatever you're tracking, however you're tracking it. Just looking for a little public visibility on the oldest stuff, so that if that.
We typically see that chart and showed by year where everything is. He's just asking if there's anything 2023 or earlier, if you could just list out after the chart why it's still in the chart, like why it hasn't been closed yet, what we're waiting on. A status update, not all the committee action, not all that, just administratively why it's still open.
Yes.
Okay. That makes sense?
That would be great.
Member Schmidt?
A question to the administrator, how many of these cases are awaiting a city attorney's opinion or input?
I'm aware of one.
What?
The deputy city attorneys are waiting at a memo from the task force outlining the questions that we're asking for answers on.
Okay, and is that one that dates fairly far back? Do you know how long that's been in that status?
There have been questions where we wanted to go back and review the minutes. I believe we've been working on who's going to write the memo for just a few months now, and we have an answer.
Okay, thank you.
So, Member Schmidt, I was asked to do this a couple of weeks ago. This is my third meeting in 2 weeks, so I just haven't gotten around to it yet.
Status is great. I just wanted to see if there was any, it doesn't sound like there's any issue on that. Good.
Member Papa?
Sorry, one other chart issue. The attendance chart, Ms. Peterson, if you could just add a line for January 1st, 2025. I know we canceled that meeting, but it wasn't in this last chart, just so that it continues to reflect the last 12 regular meetings, whether we held them or didn't.
And just clarification, we're not including special meetings on that.
Correct.
That's
right.
We're just
Yeah,
listing.
well, right. So the way we discussed is to list every regular meetings. That's, there should be 12. So it's clear people can look back on all 12 and see. And if there's no meeting, you can just, exit out or however it is that you indicate on the chart.
I'm good with the admin report. Thank you.
Okay. Anything else for the admin report? Not here. Okay. Let's take public comment on that item just in case.
Anyone wishing to make public comment on item 3, please approach the podium if you're in the room. If you're online, please press star 3 on your phone or use the app. Give you a moment. We have no one approaching the podium, no one online.
Okay. That item, no action on, and we'll move to item number 4. Oh, I'm sorry. Did you have something for item number 3?
I have a question.
Oh, sure.
So I'm curious about so in terms of attendance, if we miss 2 regular meetings, then obviously the matter comes up. We're not supposed to miss more than 2 regular meetings, but in case of situations where we have, say, like a special meeting 1 month and a regular meeting the month after that, is attendance in the special meeting counted towards?
No, it's just regular meetings is the way it's worded. So you can look at the bylaws for the specifics. There's separate for how many consecutive you can miss versus how many in an annual rolling 12-month basis, but it does not count special meetings and it does not count committee meetings. So it's just the first Wednesday of every month meetings.
Okay.
Yep.
Thank you.
So if you can't be here for, let's say, a committee meeting or the special one we had 2 weeks ago, that doesn't count.
Okay. Thank you.
I'm
Sorry. I don't think we need to renew Member Highland's motion to continue the administrator's report, but perhaps for next time, if we could include in the packet both this report as it is and the next report so that there's public visibility of this report as it would have been presented.
That makes sense.
Thanks.
You all set? Okay. All right. I think we're ready to move on. Item number 4.
Item number 4, approval of the 2024 annual report. Members of the public can view these documents online. No password or identification required, or review printed versions in the agenda packet. Public comments on these documents can be sent directly to lstein.soft.
TF. That's wrong.
It should be SOTF, lstein.sotf@gmail.com, or made during public comment on this agenda item. I do want to note that there is a new version of the PDF of the annual report that has some non-substantive changes that was added online. The item in the packet, which is here in the room, was printed on that was printed yesterday prior to the online change.
Okay, do you want me to turn over to you first?
Yeah,
Okay, go
I
ahead.
kind of want to deal with the more immediate matter of this sharing of documents problem. I am seeing the same problem that Mr. Warfield was describing. When I actually try to log out of all my accounts, I'm not getting the link for the public that's supposed to be there, but I'm also having trouble creating it, even though I know it's supposed to exist on Google Docs. When I've created it for one document, it's connected me to another document. So I think there does maybe need to be a delay in hearing this item, and I need to figure out what links are going to get people to the correct place without having to sign into Google. And I don't know why it worked out that way, because when I tested it, it seemed okay, but it doesn't seem okay now. So
Yeah, and
I don't know if anyone else has had this problem.
I have not, but I'm always logged in.
Okay.
I'm able to log into it now, not logged in.
Yeah, I thought I was able to log into it, not logged in, but then it was kind of automatically logging me in.
Yeah,
It was letting me look, so I logged myself out of everything, tried to share it with the public just through the drive, which is the 2024 annual report drive. And when I click on that link, not logged into anything, it just sends me to the next request report. I don't know why. So I think I have to figure that out. But I do also want to mention that some of the materials that are there that I've linked to or tried to link to, which I will again try to link to, are not the annual report itself. They are the source documents that were used for either to organize the data that was used in the annual report or to draw on data for the annual report. So that next request document is not technically part of the annual report. It's just a source of information that was used, but I've posted it so everyone can see the source and the materials that I use to draw data or to organize the data.
Member Highland here. When you logged out to try and log into the prefer not to use the link PDF option, did that come up for you?
No, it didn't come up for me.
So I just checked not logged into anything and they all opened for me. However,
Like showing an icon of your Google account in the corner.
no, I'm in incognito mode and I'm not logged into anything. So, but I'm happy to assist at least to just like double check what you have done with the settings for it over either on the break or afterward. No, I mean, I would have to look at like what you've done.
I guess also the other question I had is, I mean, up until now, this has been a collaborative document where members of the public can see us.
Well,
the changes.
they're supposed to be able to see us, but if they're linking on it and they're not getting anything, then they're not.
So how long have they not been able to see us? I guess is my question. We don't know.
I really don't know.
We don't know. Maybe IT can tell us. Yeah. Okay. All right.
Yeah. I haven't gotten any feedback from any member of the public, so.
We did this last year and it worked, right? It was.
I thought it did.
Online collaborative.
Yeah.
I think members of the public stood up and told us how they thought it was cool. They could watch.
That's what I'm saying. I think given this, we should postpone it a month, put it on the agenda again. People will have a little more time to make comments on the Google version, but the members of the public can also, if the links are correct, then, email me if they have any suggested changes.
Maybe I'll make a motion to continue to follow the chair.
Sure.
Do we have some further discussion?
I mean, we can also have further discussion if people have feedback based on what is here.
Well,
but we won't take any action.
Should we talk about that if the members of the public aren't able to
Maybe.
access what we're talking about? So that's why I'm saying we should just continue it and then otherwise we're gonna have that same discussion again at the next meeting, probably.
Yeah, and anyone is, welcome to make comments on the document directly or to email me if you have overarching issues.
Yeah.
And another thing to consider is that your email address was incorrect.
Yeah.
So
no one could even have.
That once, but I guess an old version was put on there.
All right. So there's a motion to continue. Do we have a second?
I'll second that.
Okay, moved by Member Highland, seconded by Vice Chair Stein to continue this item to the call of the chair. And I would intend to put this on next month in case, unless there's some further technical issues.
Okay, and I'm sorry, I didn't hear the second.
Vice Chair Stein.
Vice Chair Stein. And then Member Pilpel has some.
I just had a couple of comments that are not directly related to the content, if I might. So on that, there's a list of task force members that's listed as Appendix E. I would just suggest that we have a little.
It sounds like it's on the content.
You talk about the content, which
I'm
members
not
of the
sure we
public
should.
can't see it.
Yeah.
So let's save that till next month.
That's the point.
Well, if we're going to try to adopt,
You can send those edits to the
no,
administrator.
I can't because I don't have the email. Can I just make? Sorry, I didn't mean to raise my voice. Can I just make a brief comment? That would just be good for me, if I might.
I don't think you should. I think you should submit it and it should go into the packet and everyone should see it together. That's what we're trying to get to right here.
Yeah. Member LaHood?
I just want to reiterate what Vice Chair Stein said, which is since Member Pilpel does have access to this, he could hand over notes that could be incorporated. Is that correct?
Sure. I mean, I'm sure the administrator could facilitate any communication channels. So Member Pilpel could give it to the administrator or directly to Vice Chair, however they want to work that out.
I'm trying to not delay adoption next month, is my point. If I could just make some comments, it would be.
So I think we have a motion, a second. This is a motion to continue. Member Pilpel, if you don't agree, you can certainly vote against it if that's what you prefer. Yes, as I said, so we have a motion to continue that's on the floor. It's been seconded. So I think we are done with us discussing it. So I'm going to take public comment on the motion to continue this item.
If you'd like to make public comment on item 4, please approach the podium. If you're in the online community, please use the app or press *3. We have one comment in the room.
Remains.
I'm Peter Warfield, head of Library Users Association, Library Users 2004 at yahoo.com, and PO Box 170544, San Francisco, California 94117-0544. And I give the email and the mailing address in case folks like Member Pilpel or anybody else who doesn't have access or doesn't want access because of the serious privacy issues. U.S. Postal Service does have rules and laws protecting the privacy, the confidentiality of mail. First of all, it was I who brought up and wanted to prepare, and Member Stein came forward and so did the chair. Had I not noticed that there were 34 pages on the copy that I got at the clerk's office today, and that there are 33 pages in the copy that's in your book, I don't know that there would have been any discussion about any of this, and I certainly support, and I appreciate the additional information, I certainly support your not taking action on this today, since I wasn't able to see anything but something or another, whatever this version is, which it's not labeled, and I have some serious problems with your whole procedures, including Google Docs. I don't know why I have to give personal information or any information. And I don't know why you have to share with Google in your work a separate profit-making company that is interested in quote unquote harvesting information to make money. I don't think that's appropriate as a way to conduct your business. Second of all, I think it's inappropriate to have the comments going to Member Stein. If somebody wants to know what those all are, what? Only one individual is able to provide what other people might have commented? Should I be interested in requesting that information? I think it's appropriate to go through the contact your support person who can then send it to wherever it needs to go. As I described, every one of the links described in this heading, hearing approval and so on and so forth, annual report links, did not work when I was in the clerk's office at the public computer with a clerk helping me. And the business about versions, I think you have what seems to be no version control that's visible and checkable. Who's changing what, when, how, where? Out of control. Finally, I want to say that it's shocking again that I don't see any evidence that complainants were asked what they thought of Sunshine and its procedures, et cetera, while asking city agencies. That's, I think, very wrong, and it suggests
Thank
that
you. Your time
Thank you, Mr. Warfield.
has concluded.
if you do a poor
Thank
job,
you. Your
fewer
time
and
has
fewer
concluded.
complaints will come in.
Mr. Warfield, thank you. Okay, do we have any other public comments on this item?
We have new members of the online community. If you'd like to make public comment on item 4, please raise your hand in the app or press *3. And we have no hands raised.
Okay, I'll go ahead and close public comment. Member Popel?
I just have one other comment on this. When this comes back, whether it's approved next month or at a subsequent meeting, rather than having the final latest and greatest version available in Google Docs, or even if it still is, could we just print out or PDF the final version and put it in an agenda item with a cover sheet as we do for all other items, so it's available for everyone as a PDF?
It was PDF.
I understand, but I'm just asking that that be done once the latest and greatest version is available. Thank you.
Clarification, we're talking about the PDF only of the annual report, correct?
Can I just ask that if anybody else is going to read it and make any comments, please do that in the next week. And then I will, have a PDF to give to the administrator, and that will be not changed before the meeting.
So deadline of, do you have a date? Just so everyone knows, if it's after this date, it's not getting changed.
I guess we would, I can give, let's say the deadline of February 16th,
Okay.
because that's okay. I can make any needed changes before the next meeting, and then whatever is in the PDF, that's it. That's it.
Yep.
February 16, close of day?
Sunday, yeah.
Member Schmidt?
Yeah, a couple things. One is, I'm not sure if that resolves the way that someone like Member Pelpel would be able to submit edits. With, I guess, do we have, if we have an avenue whereby that can happen? I'm not going to go further on that. I just want to make sure that that can happen. And the second thing is, I'll vote for the motion to continue, but I am concerned about some of the aspects, not all, but some of the aspects raised by Mr. Warfield, in that I think if we still had some of the technical challenges that truly affect members of the public's access to the documents at the time we vote to approve, I'd be concerned about that in terms of like the validity of voting yes on approving this. So I just want to make sure that we've got all our ducks in order so that there is access, and hopefully it won't be an issue at the time we vote. That's all.
I'm going to be trying to resolve this access issue in the next 24 hours. Because I know there should be ability for the public to go online and look at these links without being logged into Google, just being on the internet. So I'm going to try to make sure that that's sorted.
And when there's a change in an item that has been already published in the agenda, I will make sure that the hard copy is also updated. The hard copies are prepared in advance, and that's not good.
I think Member Warfield's point is well taken as well. We should probably have a revision date or revision number, just so it's easy to compare which version is which one. So I think that's helpful to have the latest revision date on there.
I can work with the various authors of any item to do that.
Okay, I think we're ready to take a vote on that motion. Again, this is the motion to continue.
Moved by Chair Hyland, seconded by Member Stein to continue the matter to the call of the chair,
Yes.
taking the vote. Member Hyland.
Aye.
Member Hyland, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Hi.
Member Sugarman, aye. Member Kumar. Member Kumar, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Wolf.
Aye.
Member Wolf, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 10 ayes.
Okay. Moving on, we're past 5 o'clock now, so we can move to item number 5.
Item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the Sunshine Ordinance Task Force's jurisdiction, but not on today's agenda. Individuals in the room, please approach the podium. If you'd like to make public comment online, please press *3 or raise your hand in the app. We have no one in the room, no one online.
Okay, we'll go ahead and close public comment for item number 5 and move on to item number 6.
Item number 6, file number 24065. Complaint filed by Anonymous, TMR, against the San Francisco City Attorney's Office for allegedly violating Administrative Code Sunshine Ordinance Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. On January 21st, 2025, the Complaint Committee, moved by Chair Schmidt, seconded by Member Stein, referred the matter to the full task force for consideration of Administrative Code Sunshine Ordinance Section 67.21 for timeliness as well as other possible violations.
Okay, and do we have the parties present for this complaint?
Hello, caller. Are you here for item 6?
I am.
One moment, please. Promoting you to panelist. Do we have a member from the respondent's office, City Attorney's Office? Ms. Quart is in the room.
Okay, and I'll just ask, does either the petitioner or the respondent have any other witnesses? Toby?
I do not.
Okay, great. Okay, so this was heard very recently by the Complaint Committee, so I'll turn it over to Chair Schmidt to give us a quick summary of this.
Yeah, a couple things. First, I want to say that the description in the agenda was a little bit off on several of these cases. I want to give Member Stein the credit for making the motion in the committee on this and two of the others. And also, our determination is it wasn't written clearly, and it may have been our issue, but we did try to make a recommendation on a timeliness violation, 67.21, and possibly other violation. And so that's what we actually determined in committee. This case, it's fairly straightforward. There was a request made for all settlements that did not include a Civil Code Section 1542 waiver. Now, I will just say that I have some specific knowledge of this. It's a almost universal situation that a release document has a 1542 waiver, and the parties have the option whether to have the waiver, but you do have to have the 1542 notice in a release. So if the city attorney's office responded to the request here and said, we don't have any releases where there was no waiver, that's certainly possible. And I think that's what their response was here. The two problems, however, that we saw, one is that there was a concern that the email request was sent to spam, and that seems to be a problem. That might be a problem for other people with the city attorney's office. I think we should notice that. And the second problem is that the city attorney's office construed the request to not include non-civil litigation matters, such as administrative employment matters. And that could be problematic from our perspective, because that's not what was written in the request originally. That's all. Members of the committee, Member Stein, anything else?
I don't have anything to add.
Okay, I think we're ready to get started. We'll start with the petitioner, who will have 5 minutes, and then the respondent will have 5 minutes. So,
Sure. I'm sorry.
I was going to say the administrator will let you know when you can begin. She's going to set the clock for 5 minutes.
Your 5 minutes
Okay,
begins
thank
now.
you. Yeah, there was good description given of what has happened, where I've sent in a number of email requests, and then after the fact, I learned that somehow my requests are sent to a spam folder or some kind of security folder. And half the time, the city attorney's office says that it takes an extra step to access these emails, and other times they say they cannot access these emails. So it's hard to know which one is correct. But I've tried my best to work with the people at the office to get these requests into their hands. And unfortunately, the people at the receptionist desk do not know that they're allowed to take public records requests over the phone. I've tried reaching out to a number of people at the city attorney's office to get this matter resolved, and none of those phone calls were returned. But I would like at least a consistent way of knowing how to get a public records request into the city attorney's office's hands to make sure that that is fulfilled. And then also, there's another issue where I did ask for all settlement agreements that do not contain the 1542 language. And then to get more specific, back on January 27th, I made another request that I specifically asked for a settlement agreement in the Lynn Rawls case. And I have a court case number of CGC-20-588-157. And I was given a 4-page full and final release, but this is an incomplete, the request is incomplete. I don't know if you guys have this document in front of you, but it's a 4-page document, the full and final release related to Lynn Rawls versus the City and County of San Francisco on page 304. In the second paragraph, it refers to another settlement agreement between the two parties that was entered into on February 8th. And it says it's Exhibit A, but 2 times it mentions this settlement agreement. And I asked specifically for the settlement agreement related to this case, not just ones without 1542. On January 27th, I made this request. And again, this is not, they have not produced all the documents related to my request. That's all I have.
Okay, thank you. We'll turn it over to the respondent.
Are you ready?
Yes.
Your 5 minutes begins now.
Hi, good evening, Chair and members. Jen Court on behalf of the City Attorney's Office. As we kind of mentioned, this complaint is really a technological problem that our office is having with our email system spam filter. Basically, what happens when this specific requester sends emails to our office, for whatever reason, Microsoft's spam filtering tool quarantines these messages. And as individual email users, these emails don't end up in our individual inboxes. So far, we have not been able to fix this problem with our IT team. We've explained this issue to the requester and suggested alternative methods of communicating with our office in the future, like calling our office. There's been some talk or suggestion that our receptionists would not accept records requests over the phone. I want to make very clear that is not the policy of our office, and our reception staff do not ever recall telling a requester or a caller that. We've had a series of requests over the last 6 months from this requester. Same thing. We've had the email problem every time. Every time the requester has found another way to alert us that they sent an emailed request, then our IT staff goes into the quarantined email folders, searches for this specific requester's email, and releases them so that they actually appear in our individual email inboxes. Every time after being notified through a different mechanism that a request has been sent, whether it's a phone call or this Sunshine complaint, and then getting the email release from quarantine, we've responded to the records requests in a timely and complete manner. Regarding the records request, specifically in December 2024, the requester asked for all settlement agreements without a 1542 waiver included, as we've said. They said our response was incomplete because they saw a settlement agreement online in a case called Lind Rawls, which we just referred to, that did not contain a 1542 waiver and thus should have been responsive to their initial request. The fully executed version of the Lind Rawls settlement agreement does contain a 1542 waiver and is not responsive to the request. We've sent both you and the requester the fully executed settlement agreement. It starts on, I believe, page 28 of your packet, even though it was not responsive to the initial request, but was responsive to their follow-up. Lastly, there was some discussion at the complaint committee about our office's message to the requester in which we were said we were excluding administrative settlements from our search. We often send messages like this to requesters. It's basically our best interpretation of what the requester is most likely looking for. If a requester corrects us, tells us that we're wrong, and they actually are looking for these things that we said we were excluding, we will then search for those things and provide those records. This requester in this specific situation never followed up to tell us that they did want administrative settlements. And the first time that we heard that was at the complaint committee. So we totally understand that this technology issue is very frustrating. It's also frustrating for us. We hope to have a productive working relationship with the requester despite this issue and get them the records that they want. But so far, haven't been able to fix it, but it's a work in progress. So with that, happy to take any questions.
So technologies are what?
Thank you. Okay, members, any questions for either party? Go ahead, Member Popel.
Okay, so let me start with the petitioner. Mr. Petitioner, since I don't know who you are, should I just refer to you as the petitioner? You okay with that?
Sure, that's fine.
Okay, so I understand that you have concerns about contact and there may be a violation of timeliness. We'll noodle through that. In terms of what you're still looking for substantively, is it not the 4-page release, but the related settlement in the Rawls matter? Are you still looking for that, or have you gotten that?
So all I've received is the 4-page document that I believe Ms. Quart said was attached to the the records that you have, and then on page 3 of 4 of that
Yep. I heard
document
that.
that's titled, yep. So it's just what I'm looking for now is still that Exhibit A.
Okay. The February 8th,
And then-
2023 settlement agreement, whatever it is.
Yes.
Okay. All right. So that's item 1. Was there anything else that you were
I believe there
still
may be
looking for?
Yeah. So I believe there are additional settlement agreements that do not contain the 1542 language, and I'm going to request those specific documents when I have the exact titles of them. And so that's how I plan to proceed with those.
Okay. So you'll submit further requests that are specific to names, dates, cases, whatever on those, but there's nothing that's in scope for one of your original requests that are before us now that you want to lay out right this second.
I do not believe that. Yeah, I do not believe that the city attorney's office has produced the documents that fulfill my initial request for settlement agreements that don't contain the 1542 language. So I do not think they've been forthcoming with those records.
Okay. Can you provide a little more color and flavor on that? What is it that is there an example of something or some area of settlements that might have, where a 1542 waiver was not applied and where you think there may be responsive records?
Well, one may be the February 8th, 2023.
Right, we got that.
Final settlement that we're talking about. And then I'll have to continue to put the list together and see what I come up with. But I think that I have a list of a few, and I'll request those specific documents, but I don't have that full list with me right now, unfortunately.
That's fine. So why don't you make that the subject of a more specific future request? That would be great. If there's nothing else that you're looking for right this second, then I wanted to turn to Ms. Court for a moment on this issue of email and maybe timeliness. I'm not sure where I am with that. So in general, when someone emails the city to a specific address, whether it's a general address or an individual, one might assume that that email is received and is being handled, but it might not. It may get quarantined, or the person may be on vacation, or blah, blah, blah. Technical term, blah, blah, blah. Although it is not, in my view, required under the Public Records Act or the ordinance, Ms. Court, could you consider, and maybe for a trial period, have an acknowledgement email that goes out? So when you or your office or whoever is getting public records requests by email, if as soon as possible, not in 5 minutes, but certainly prior to the applicable deadline, if you could spit back something to the requester saying, we got your request, it was received on this date, either it was an IDR or it wasn't, whatever, we're looking for stuff, here's what we understand you're looking for, we got your request. Something that essentially acknowledges the request, and so it's not just that they send it into the hole of color, but that it goes somewhere and that they get something back saying, we got it. And you could include in that whatever you want, if we got it wrong, if you need to clarify or narrow or blah, blah, whatever, that at least they have something. And then we all sort of have a clock that started, and that it's not just that they sent it and it never got received. Because as far as I'm concerned, if someone sends a request, that's great. But if it's never received, I can't expect you to respond to a request that you never received. I can expect you to respond to a request that was actually received. Does that make sense?
Yeah, the concern that I would have about that, and we would need to see if this is even, if that would even work with our IT folks, is because for whatever reason, this is not a spam filter or quarantine filter that we control. This is Microsoft's like proprietary AI that basically decides what emails like go into this kind of black box. I'm just concerned that even if we did set up an automatic message that's like received, something like that, I'm concerned that in this specific situation, the emails that go to this kind of quarantine black box wouldn't receive those. Like it wouldn't trigger it. That's what I'm worried about.
Understood.
Yeah.
It may not, but at least in your public procedures, you could say, we acknowledge emails received, blah, blah, blah. So if you don't hear back from us within a day or two, you might want to call because it might have gotten lost, right? This same issue has come up, not just with your office, but I recall with Ms. Trabeau, with any number of other requesters that have either gotten a letter wrong, set it to SOFT rather than SOTF. That there are a lot of issues with getting the right email address and it actually getting through. The theory is that all email gets through. The practice is it doesn't all get through. And it's not necessarily on you. It can be Microsoft. It can any number of things. So that's why I'm suggesting just to try that. And then if someone says, look, I haven't heard from you in a week, blah, 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 then you go root around and you say, oh, actually, we never saw it because blah, blah, blah. Thank you for calling it to our attention. We'll get right on it or whatever.
Yeah, I think that's a good suggestion. And we can certainly do that for our public records email address. That seems logical. For individual people's email addresses who receive records requests, we obviously wouldn't be able to set up an auto reply for every email they receive, but for the public records email address, that might be a good stopgap solution.
And remind us, what is your general city attorney?
It is public records.
Yes.
At sfcityatty.org.
Okay.
Yeah.
All right. So
that's not correct.
Okay. Maybe there's some dispute about that. In any event, this is why I think we were trying to encourage departments to set up an address that's not connected to a person that multiple people can look at and that can have whatever system set up. So it's not that you're, trying to get a public records request to a bus driver or a staff nurse at General, but that if you send it to records requests at sfcityatty.org, that somebody's going to be on that many times during the day to check it. Okay.
Makes sense.
So as to completeness, you've got a request now on this underlying settlement. You now understand that somebody will try to provide that ASAP?
I understand that they want Exhibit A.
Whatever that is.
Okay.
Okay. As to timeliness?
May I add something real quickly, please?
No. We're not doing it that way. But each member gets to ask questions either to the petitioner or the respondent. If we have questions for you, then we'll ask those questions to you, but please do not interrupt. Go ahead, Member.
Certainly.
And Mr. Petitioner, you will have an opportunity for rebuttal at the end, which we do want to hear. So to Ms. Court, on this question of timeliness, despite the technical issues and whatnot, can you tell us how quickly your office responded once you were aware of and actually got the quarantined emails?
Yeah.
That would be great.
I do want to, so basically the day that we realized and a request to come in is December 20th. We were late in invoking an extension. We had invoked an extension on January 2nd. Technically, we should have invoked an extension on December 30th. However, when we invoked the extension on January 2nd, we counted 14 days from December 30th, what would have been the day we should have invoked the extension. And 14 days from December 30th was January 13th, and that's when we ultimately responded. So overall time frame, I think we were on time, but the invoking of the extension, we were a few days late.
All right. Thank you.
All right, thank you.
You can go ahead.
Member Kumar, then Member Sugarman, then Member Schmidt. Okay, go that way.
Okay, I just realized it's a comment, it's not a question, so I'll save it for them.
Okay, sounds good. Member Sugarman.
I just have a question for the respondent. From what I'm hearing, there hasn't been a remedy to the spam issue for this particular instance.
That's right. Yeah, we're still working on it. Can't really figure it out, to be honest.
Okay. And for the petitioner, I heard you say briefly that there was a different email address. I was wondering if you could tell me which one that was that you were using.
Sure, it's the one that I received all the responses from. It's public.records@sfcityatty.org.
There you go.
Apologies. That's an oversight on my part, saying it out loud. Yes, there is a dot.
Okay, just making sure. Those are my questions.
Okay, Member Schmidt.
All right. First, let's see. I just have one question for each of the parties. First, to respond it. So there's nobody at the city attorney's office who goes into the spam and checks if there were any mistakes or things like this, correct?
Not on a regular basis like that. And the way that our IT team explained that to me is that there are many emails in there that we get that are like truly dangerous phishing emails, like they're security risks. So they don't want to be basically opening up every single one of those because it would be some sort of security risk, as I understand it. So they're not kind of monitoring in that way and going into every single email, looking through them for records requests or other things like that. So basically, the answer to your question is no. No one is kind of doing that close of monitoring.
Okay, so there's nobody who's looking at just the title or the brief description of the email that would show up in a list of all the quarantined emails. There's nobody who's going through and trying to pick out, oh, this one may not be what obviously a lot of spam is obviously spam, but there's nobody who's going through and trying to find out if something looks like maybe it doesn't belong in the spam file.
In the quarantine email, no. When our IT team gets notified by some other employee in the office that's like, hey, I didn't get this. Is there a reason I didn't get this email? Then they will go in and specifically search for that. But the way that what they told me is that going through each one would present some sort of security risk.
Okay, it sounds like, okay, I think I've got the answer on that. Thank you. And question to the complainant, when you heard back from the city attorney's office that they were going to respond to you, but they weren't going to respond with regards to administrative matters, only with civil litigation matters. You didn't agree with that limitation, did you?
I did not.
Okay. And you haven't received an answer with regards to administrative matters that may not have included a waiver, correct?
I don't believe so, other than what Ms. Quarta said during these meetings.
Okay, thank you. No more questions.
I have a quick question for you, Ms. Court. The technical problem that you seem to be experiencing, is it with anything that comes from the protonmail.com, or is it something specifically with this sender's email address? I'm just curious.
No, this is kind of the crux of the problem. It's not just like a specific email domain or from a specific person. Our IT team told me that basically this is like this quarantine filter is Microsoft's like proprietary, it uses AI. So it's always basically kind of like changing. So he explained to me that he could send me an email. He could write it out in a way that's kind of like weird, include links, include like suspicious attachments. And even though it's from one person in our office to another person in our office, he could make that email go to the spam filter or go to the quarantine filter. And so it's something that's kind of always changing. And we don't really have the ability to say like, let everything from this email domain in.
Okay,
It
that
just kind of
gets
makes
to
it-
what I was asking. So it's not
Yeah.
as easy as just
Yeah.
saying, hey, let's turn on protonmail.com.
Yeah,
Okay.
unfortunately, no. If it was that easy, we would do that.
Got it. Okay, that's all I had.
So can I just pick up on that for a second? So again, back to the procedures, and I believe that you do have a blurb on the city attorney's website about how to submit a public records request to your office. I seem to think so. Maybe
Yeah,
not.
there's a page.
Okay.
Yeah.
So, that's why I recall it, but I don't recall the specific language. Could you maybe take a look at that language sometime? And if there's a thing that says you can send email requests to blah, 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 maybe add a sentence or two that says something like, be aware because of the nature of the world, not all emails may get through. If that's not working for you, here are some other things you can do. Send it by mail, give somebody a call, drop it off, blah, blah, right? That there are other options. So one should not have this is very much about managing expectations, right? And this particular requester, in my view, shouldn't have to wait and follow up and do all kinds of stuff if the person in good faith submitted what appears to be a records request. So again, it's not just what you do, it's how it's packaged and perceived.
Right. Yeah,
Thanks.
I think that's a good, fair suggestion. Yeah.
Okay, thank you.
Okay, we ready to move to rebuttals? Okay, let's go ahead and do rebuttals. So we'll start with the respondent. You'll have 3 minutes, and then we'll move to the petitioner for the final 3 minutes.
Sure, thank you.
You have 3 minutes if you just want to make it. Yeah.
Sorry, I knew who's going. I don't think I have much further. I think we've covered this pretty thoroughly. Our goal really is to try and get the requester the documents that they need. And a lot of times we see kind of those back and forth and conversations as like truly a conversation to understand what it is that they are looking for. And granted, we do have some communication challenges with this particular requester, but technological challenges. But, we do want to encourage the requester to kind of, if they think that our response is incomplete or they want administrative settlements, like to tell us that, and then we can follow up. That we don't want to find out at a complaint committee hearing or whatever that that's in fact what their request meant. So that's really a function of trying to understand and prioritize and all that. So I don't think I have anything else.
Okay, thank you, Ms. Court. We'll go ahead and turn over to the petitioner. We'll have 3 minutes.
Petitioner, are you ready?
Thank you. I am.
Your 3 minutes begins now.
Thank you. I just wanted to add that this initial request was made on December 6th of 2024, and that should be page 11 of 64 in your packet. So the initial date was December 6th that this request was made. And then secondly, I have tried to work diligently with the SF City Attorney's Office for alternative means of communicating with them. I've asked for a phone contact. I've left phone messages. Those calls are not returned. I did reach out to Microsoft, and they said that one way of overcoming this current issue would be for the SF City Attorney's Office to add my email address to a whitelist to make sure my emails get through. That was one thing that I've learned since the last hearing. And then I think the last thing really is just like the Sunshine Ordinance Task Force has a Google form as their form of contact for filing a complaint, which I used and had no problem using. I think that if the SF City Attorney had a Google form for records requests, then we could overcome this entire issue. We wouldn't be here if they had that form. And I've I've brought this up to them a number of times, and they're just not receptive to the idea. That's all I have.
Thank you.
Okay, thank you. All right, members, how do we want to proceed on this one? Member Kumar, you said you had a comment earlier. Did you want to kick things off?
I just wanted to say, I see this as a clear case. There is a violation, but I just wanted to appreciate the department for accepting that there is an error and they're trying to fix it. That's all I wanted to say.
Okay, thank you, Member Kumar.
I agree with that, which is probably all I have to say as well.
Okay. We have a motion.
Was this something we could find for violation and then move to, like, is it something that the task force can follow up with on the committee level to make sure there's a remedy for it?
Sure. Yeah, we could send it to CAC. And that's okay.
May I ask Ms. Court a question then?
Sure. Yeah.
Ms. Court? So it sounds like there were, the petitioner thought he was clear about what he was asking for, but it sounds like there was some confusion, or that your interpretation was less than what he was looking for. Would you be able to do that expanded search?
Yes.
Okay.
Absolutely.
Yeah. CAC can accept this. Sure. I mean, we would have, yes. I feel comfortable that we can accept this and that the petitioner will get more records.
Does that answer your question?
Yeah.
Okay.
Further, if we do find a violation, however technical or on timeliness, and did have that back for compliance, Ms. Court, you could also report on what else you've been able to accomplish in terms of filters and websites and whatnot.
And whitelisting.
Yeah.
Yeah, I can ask about a whitelist. I will say after the complaint committee, I did again follow up with our IT folks, and I mean, it's only been 2 weeks, but like, not much, they were pretty clear about what they had told me beforehand. So I'm not like super optimistic that we're going to be able to fix the Microsoft like spam issue, but I do think there's other like mitigating things that we can do. So,
and that may be what we can explore further. Yeah. Okay.
Can I get a clarification on the details about the referral
I'm sorry?
for the motion?
There hasn't been one yet.
We haven't made a motion yet.
No.
No, I was suggesting one, but I assumed that someone would probably want me to move for it, which I can do.
Okay, well, let me, before, as we go to consider a motion, I think we should be specific. If we're looking at timeliness, what part of timeliness are we finding? I mean, the respondent admitted that they were late in invoking an extension, so I think that's obviously clear. I think there's more ambiguity whether or not the timeliness extends necessarily to the initial email, since I'm not sure, at least personally speaking, whether the respondent had a lot of control over that. The December 6th email, since they never saw it. But maybe we could talk.
Still seems, I mean, it sounds like it's a technical issue with this specific instance that still potentially has a timeliness issue at the start of it. That needs to be, that's why I asked the question initially, like, have you found a remedy for this? Because to me, if it's happening with one person, this person is trying to get information, they know that there's this issue, then, I mean, I did not ask the question, but in my head, it would be like, you can set up a separate email or something else to like work around that. And that was not discussed. So to me, it's like, well, we knew this was an issue and we haven't found a remedy yet. So to me, the timeliness extends to like the initial request.
Do you want to make that as a motion?
Well, mine was, please anyone can tell me how to make, like, it's been a minute since I've made a motion. But I motion to find the city attorney's office in violation of the Sunshine Administrative Code 6721 for failing to respond to a public request in a timely manner. And I further recommend to send this to the Sunshine Compliance and Amendments Committee to follow up with the petitioner for how to resolve this technical issue.
Technical issue, are we also going to do for the remaining records as well?
As well as to provide the records that the petitioner requested.
Okay. Did you get that?
Or any other approach, whatever, something brief about what else they might be doing.
Yeah. Let's see what Ms. Peterson has first.
Moved by Member Sugarman to find a violation of 67.21 for failing to respond timely and refer the matter to the CAC to follow up with petitioner for how to resolve this technical issue and requested records and any other whatever. Sorry.
Aren't we, I mean, the respondent needs to provide the records, and I think the respondent needs to provide a solution, right?
That's correct. Yes. That's what I meant.
To follow up with respondent.
Or to follow up in general as to requested records and.
Well, to refer the respondent to the Compliance and Amendments Committee to resolve, to confirm resolution of this technical issue with the petitioner and confirm that they have provided the appropriate records that the petitioner requested. Does that sound correct?
So return to the committee with resolution by respondent.
Yes.
On the production of records and
technical issue resolution.
Okay.
Is that okay? Okay.
Technical issue is resolved and correct. Could you speak into the mic, please?
I think it's good the way that it sounds.
One moment, please. Okay. Is there a second?
I'll second it.
Okay, seconded by Vice Chair Stein.
Okay.
All right, we have a motion, a second. Any discussion on that motion? Should we move to public comment? Okay, not seeing any hands from the members, so let's go ahead and move to public comment on that motion.
Anyone in the room wishing to make public comment, please approach the podium. Online community, please raise your hand in the app or press *3. We have no one approaching the podium, no one online.
Okay, go ahead and close public comment. If there's no other comments from the members, I think we can move to a vote on this.
Member Sugarman.
Aye.
Member Sugarman, aye. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Highland.
Aye. Aye.
Member Highland, aye. Returning to Member Anderson. Member Anderson.
Aye.
Member Anderson, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Wolf.
Aye.
Member Wolf, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 10 ayes.
Okay, thank you both parties. And our administrator will be in touch about the follow-up hearing. Okay. We're ready to continue. Does anyone need a break or should we go ahead to the next file?
I would like a break.
Want a break? Okay, we'll do a 10-minute break here. We'll be back at 6 o'clock.
Mics are off.
I made it.
Microphones are on. The time is
6:03.
6:03 p.m.
Okay, let's move on to our next file. Item number 7.
Item number 7, file number 25001. Complaint filed by Aaron Wilson against Department of Homelessness and Supportive Housing for allegedly violating Administrative Code, Sunshine Ordinance, Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. On January 21, 2025, the Complaint Committee, moved by Chair Schmidt and seconded by Member Stein, referred the matter to the full task force for a hearing to find a violation of the Administrative Code, Sunshine Ordinance, Section 67.21, for failing to respond to a public records request in a timely and/or complete manner.
Okay, let's make sure we have the petitioner and respondent here and see if they have any witnesses that they brought with them.
Hello, Mr. Wilson. I am promoting you to panelist. One moment, please.
Can you hear me? Aaron Wilson here.
Thank you. One moment, please. Mr. Wilson, you're now a panelist.
Thank you. Can you see me, by the way?
We can see your initials. One moment, please.
Oh, so you can't see my face. Okay, let me turn on the camera then, so I could not hide from you. All right.
Mr. Robinson, promoting you to panelist.
Can
we
you
have
make
the bar?
clear that even if you can see him, that we can't see him? Because I think
Yeah, not every member is necessarily running the WebEx platform, so we can't necessarily see you unless we happen to turn on the WebEx platform, which is not a requirement. So you can, long story short, you can stay on cam. You don't have to turn your cam. It's totally up to you.
Okay, fine.
Task force members, DeVaris Robinson, respondent, has been added as a panelist.
Okay, and
Can you hear me all?
yes, we can.
Volume is good.
Okay, and do either of you have any witnesses that you're?
No, I don't have any.
Okay.
Neither do we. It's just me.
Okay, sounds good. All right, so just a moment. I'm going to turn it over to Chair Schmidt, who heard this in the committee, to give us a quick summary, and then we'll get to you for your opening statements. So Chair Schmidt, go ahead.
Okay, I do want to first just make a comment that we're in the 25s now, 25001, which is quite an accomplishment for this group because it's February 5th. And we're hearing a case under 6721 within the statutory required period of time. Oh, I thought it was 45.
30 days, 30 days, statutory is 4.
Yeah. So I do want to point out, though, that at least initially there may be some glitches in moving so fast. And one is that I think some of the descriptions on what we did in our committee are a little bit off. But I went back and I found out what, some details that are coming up. But that's sort of the good news, bad news kind of thing on the fact that we're looking at something that just came in compared to 9, 12, 15 months later. All right. The Wilson request is fairly straightforward. The request is for emails that mention Wilson, Aaron Wilson. The Department of Homelessness responded basically saying, why don't you submit a client request form for your own personal information. Now, the client request form would be used to obtain information that would not be public, that's sensitive. And it's not really the subject to this matter. I don't know if Mr. Wilson did submit such a thing. I think that we found out that Mr. Wilson is a client.
Sorry.
But that's somewhat separate. What we did find out in the committee is that.
Hang on one second.
One moment, please.
I can't hear him.
Okay, we had a member of the hood tried to sabotage us, but we fixed it. The client request for confidential information, we don't know if that was made, but it's not really that relevant. What Mr. Wilson emphasized is that what he's really looking for here are emails that may not be subject to that type of confidentiality, which is internal emails within the city department that may have discussed Mr. Wilson. Now, we found out in the committee that there were, in fact, about 164 such emails, and those have not been provided, I believe, to Aaron Wilson. At the committee, I made the motion that we move it forward, but I did not make a recommendation on this. So there we go.
Okay, thank you. So we will start with the petitioner, Mr. Wilson. Our administrator will let you know when you can begin, and you'll have 5 minutes.
Mr. Wilson, are you ready?
I'm ready.
Your 5 minutes begins now.
Okay, I tried to make a very narrow request to respect the office's time and resources. As it turns out, I've gotten nothing, even with the extension to this point. Now, it's pretty clear I mentioned emails 5 times in my request. No response from Tavares ever mentioned emails once. So we'd have a disconnect there. He only suggests things like documents and so forth. And of course, that's not what I'm requesting. I think it's pretty clear in the request that I'm not requesting records or my personal records. But that's where he steered me, and that's where we are today, in suspense there. And of course, to get my personal records, I've got to give social security number, birthday, etc. So, you know, that's not really what I'm looking for. I'm looking for the back and forth. For example, if HSH employee 1 is talking to HSH employee 2, and they mention Aaron or Aaron Wilson or Bayview VTC in conjunction with my name, that's what I'm looking for. And why? I'll give you a little bit more information. There's been a lot of prejudicial statements made in the media about us who live here at the Bayview VTC. So we know that they have these kind of conversations with the press. We think that they have conversations between themselves as well. I mean, if they're so flippant to say it to the reporter and it gets published, it's really defamatory, really. I want to know what they're saying behind the scenes. So that's what my request was about, and not my personal records. So let's give Tavares the benefit of the doubt. It's all in my personal record. Anytime they mention Aaron, it goes into my personal record. Well, there should be basically 2 groups or 2 piles of emails. Ones that are specific. This is Aaron. He's mental health evaluation, his disciplinary, or any sorts of number of things that would be, you know, that you'd want to keep private. And then stuff that is not like that. Hey, Aaron, we saw him. He had his shirt off. at the VTC. What should we do about that? See, that's not really my personal record. They're just talking about me. See, I want to know that, and I'm entitled to know that under FOIA. So this is the sort of stuff that I want, but of course, I'm not getting it. And so I ask myself why. Maybe there's something to what I'm seeking. There is prejudicial stuff, and they want to hide it. So my request would be next. Has HSH told Tavares to gum up the works here, throw a monkey wrench in the works here, and not give up what I'm seeking because they know they said things that were prejudicial and they don't want to get busted? That's what I think is occurring here. So that's all I have to say. I think the opening topic done by the president there of the board, chairman of the board, summed it up perfectly. I almost couldn't say it better myself, but that's where we are today. I haven't got anything from them. I'm really not interested in my personal records at this moment. Sure, they'd be nice to have, but then they'll say they complied. And I'll say, no, there's nothing here about me when these people are talking about me. And like I said, I know they talk about me and others here because they're talking to the press about us, and it's published, and I can prove that. Thank you. That's all I have.
Okay, thank you, Mr. Wilson.
Thank you.
All right, Mr. Robinson, you will have 5 minutes. Our administrator will let you know when you can begin.
Mr. Robinson, are you ready?
Yes, I am.
Your 5 minutes begins now.
Perfect. Thank you. And for the record, it's Tavares, not Tavares. It gets confused, but Tavares.
I apologize.
All are aware, both the Public Records Act and the Sunshine Ordinance exempts from public disclosure any records that are confidential under federal, state, and local laws. This complaint regards a request for records about a specific client who has accessed homelessness services at an HSH-funded program. We consider an email to be a type of document, and the issue is that this hinges on emails referencing a client. As a covered homeless organization subject to HUD Homeless Management Information Systems final notice, HSH has an obligation to 1, safeguard client information to prevent privacy breaches, and 2, verify all requests for client information to ensure compliance with federal privacy standards. Identifiable information about specific clients must be protected regardless of the format or medium, whether it's emails, reports, HMIS data, and so forth. HSH has an obligation to protect against identity theft. To verify a client's identity, we use the client records request form, which requires specific details like date of birth and social security number to assess and validate requests. Another reason we use the client record request form is because it allows us to verify the request by comparing the signature on the client's record request form with the signature on the client's release of information, where applicable. HSH has a pretty straightforward and reasonable process to verify requests for information about specific clients. This process has been clearly described to the requester on multiple occasions. All responsive records have been reviewed, and we are waiting for Mr. Wilson to submit a client record request form for them to be released. Ultimately, we did respond to Mr. Wilson's request in a timely and complete manner, while also working with our privacy office, who stewards client record requests with my collaboration in instances where the request is made as a public record request, and the city attorney, to ensure proper guidance was given so we could ensure that responsive records would be prepared in advance of the requester's submission of a client record request form. This is all outlined in my supplemental documents that I provided in advance of this hearing. And with that, I'm happy to take any questions.
Thank you.
Okay, thank you. Members, any questions? Member Kumar, go ahead.
This is a question for the department. I just wanted to understand what are the categories under which you've classified Mr. Wilson's request? Which requests now fall under the Sunshine request and which fall under the other requests? I'm just trying to understand that.
No, that's a great question. We consider this entire request to fall under a client record request. We use this simply because the requester alleged to be a client of the department, and we have no other way of verifying that. We can get this type of request from anybody out in the public. I'd also like to add that the requester has effectively relatively rescoped the request. The initial request was for both emails and data about Aaron Wilson, specifically made by the requester. But for the purposes of this record request, we have converted this to a client record request, which is essentially not considered public information.
Question.
Do you have Member Kumar?
I have a follow-up for Mr. Wilson.
I'll get you Member Wolf after Member Kumar. Go ahead.
Okay.
Mr. Wilson, there are it's a 158-page document. So can you tell me what your original, so I'm just trying to understand the timeline here. So can you please give me some context about what your first request was for documents and whether you have changed those requests along the way, and if you have, when and why?
No, nothing's changed. I still want the emails of any discussion, like it says in the request. And this is the first time I've heard, he didn't say this at the first hearing we had, that they are classifying everything as personal records. Okay, this is the first time I've heard that. So you should have said that the first time. But nothing has changed on my part. I still want to know if I am mentioned in any discussions between HSH, Baby Hunters Point Foundation, HSH and HSH, HSH and Urban Alchemy, and I think those are the parties covered. I want to know the back and forth in an email discussion. I know they exist, okay? Also, there are my emails to them. I would think that most of the 160 are emails that I am talking to them. Okay, that would be my guess. But certainly there are those emails. So they have to produce those emails that I already have, the ones that I generated in a discourse back and forth. But I'm not talking about those. I'm talking about, again, where HSH1 is talking to Urban Alchemy 1. Those ones, okay? He's saying now that those are now my own personal records. How do they have the time to filter all that and put it on over? Is that what you're saying you did, Mr. Tavares?
We don't have discussion between the parties here.
Okay.
Just,
did I answer your question, ma'am? I'm sorry.
You did. Thank you so much.
Okay, Member Wolf, you're next.
Thanks. To the respondent, Mr. Robinson. Is the petitioner who is present today the same person who they are referring to in the request?
That's part of the difficulty with this record request. I would like to think so, but we've still not been able to verify his identity. And also at the previous hearing, the camera wasn't on, so I can't even tell you that it's the same person speaking today.
Is the name not the same? I mean,
The
what
name
makes
is
you
the
think it's a
same.
different? What makes you think it's a different person?
I mean, for us, it still hinges on needing to verify the identity of the individual. And again, this individual is stating that they've been a client. We've also made note to the requester that there are more than one Aaron Wilson in our system, all of which have different date of births, all have different social security numbers. The email that they utilize for the request does not match any of the Aaron Wilsons that we have in our system. So again, to work with him, we're like, if you can submit the client record request form, we're happy to get those records over.
Okay. Next question. Under which laws or codes or regulations are you claiming confidentiality? I mean, you made a very broad statement that it's under state and local law. Which ones are you classifying these as confidential?
Give me 1 second to outline that for you.
I didn't see it in your response.
Oh, understood. It was included in the supplemental response that we made to the requester as to why we would be violating laws if we release them. But essentially, San Francisco Admin Code 671G acknowledges that there are exemptions for record that are confidential under federal, state, or local laws, including personal client data. But essentially, this all hinges on the HMIS Data and Technical Standards 24 CFR Part 580, which establishes the requirements for data collection, management, and privacy protections in the homeless management information system. And then it also focuses on safeguards personally that identify, personal identifying information of clients who received homeless services, which in this case would be as simple as identifying the name of the client.
Okay, you realize under 671G, there's a second part to that says that a person, if they're before a policy body or a meeting body, they have a right to an open and public process. And so if they wanted to have those, their privacy revealed, they had a right to do so. Okay, that's all the questions I have, Mr. Chair. Thanks.
All right, thank you, Member Wolf. Member Pelpel.
Okay, so let me start with Mr. Wilson, the petitioner. So regardless of your living situation or receipt of services, you have concerns that you have expressed, and you believe that you're asserting to us that you have communicated with HSH, and you believe that they've communicated internally about you, your thoughts, your activities, whatever, and with either other city departments or specific contractors. Is that what I'm getting?
Yes, sir.
Okay. And you're, I think, trying to distinguish for us between your client files, if you will, and as to your particular circumstances and whatnot, and your, maybe I'm going to call it a public persona. Does that sound about right?
Yes, sir.
Okay. You are at this time not seeking, not, maybe interested, but maybe at a future time, but not within scope of this request and this complaint before us. Are you looking for your own sort of client related records? You're looking for the public persona stuff. Is that about right?
Yes, sir. That's correct.
Okay. And you've made that fairly clear for the last few weeks.
Abundantly.
Okay, got it.
Abundantly clear.
Let me also just digress for a second, since we just spent a little time on the last case talking about Proton Mail. Since your email is coming from Proton Mail, you have had no issue whatsoever in communicating with HSH using Proton Mail?
No, not at all.
You reach them, they reach you, it's all good.
Absolutely.
Okay. So perhaps they have a different Microsoft spam filter. All right. Anyway, thank you. So let me go to Mr. Robinson. Yes?
Yes, sir.
Okay. So I don't think we've interacted before. I've dealt with Dylan Schneider previously, but I understand you're the not so new anymore, but the current HSH Sunshine person. Yes?
Correct.
Okay. I understand your concern about client confidentiality and whatnot as relates to client records. I get that. For whatever complicated series of things, whether it's a privacy thing, a HIPAA thing, a federal thing, a thing, whatever, you're concerned about that and don't want to release and shouldn't release client records without verifying that it's actually a client. That's fair. Okay. To the extent that this person, Mr. Wilson, has, as I was alluding to, a public persona, how might you, if you have not yet done so, distinguish between the two? Can you imagine that there may be email communication within HSH about activities of or views of or whatever related to Mr. Wilson, unrelated to his eligibility or receipt of services as a client? How do you or how does HSH make that distinction? And if you're doing so, and if not, why not? Can you talk about that a little bit?
Question. No, that's a great question. And I just want to add, though, that I'm confident in pushing back just because I think it would be a really dangerous precedent to release records related to individuals receiving homeless services to anybody in the public. I think trying to navigate this concept from the space of Aaron being someone who has a public persona who has alleged to be a client hinged on that comfort being satisfied by him submitting a client record request form. We do try to work with the requesters really as best as we can to get records to them as effectively as possible, as quickly as possible. Again, we're not hiding anything. I've already reviewed the documents. Our privacy officer has also reviewed the documents as he stewards client record requests. So again, in terms of trying to gauge what you're getting at, we really just try to satisfy through the client record request form, which also isn't even just for a potential client. It can be for somebody requesting records on behalf of a client, where the client would then identify that they want to have those records effectively released to the requester and signature. So there's a lot of ways that we gauge that. But in terms of the public persona situation, we didn't think that that really applied here because they alleged to be a client. So we focused on the client aspect of the request.
Okay, but I'm not sure, and I don't know how the task force is going to go with this, but I'm not sure that you get to make that choice. I mean, let me just give you a slight hypothetical and a little reality. You have an oversight commission, you've got staff there. I haven't attended an HSH oversight commission meeting. I am not currently a client of HSH, not receiving any services. If I made any public comment at the meeting or requested records or chose to involve myself in the budget or your administrative process or whatever, I might develop a reputation, and there might be emails back and forth saying, you know, who's that guy? What does he care about what we're doing? And why is he interested in the vehicle triage center or Urban Alchemy's contract or, you know, performance monitoring or whatever the heck, right? And so there might be emails that would be subject to release. Just because I'm not currently a client doesn't mean that I can't have a public persona, for lack of a better term, as relates to HSH. And even if I were a current client, that public engagement bit is separate from any records that you would appropriately not want to disclose or could not disclose under applicable laws. So I'm struggling to figure out how you can't or haven't distinguished between the two and provided, as Mr. Wilson asked for, emails mentioning him as relates to Bayview VTC and HSH, emails mentioning him as relates to discussions by Urban Alchemy and HSH. Same thing with the Bayview Hunters Point Foundation, et cetera. It seemed like he was being pretty clear and specific in his request and wasn't asking for client records, wasn't implicating any of the services he may or may not be receiving. So, yeah. So is this the first time that you've dealt with this kind of a request, or is this normally the way you would deal with a records request unrelated to client records?
This is not the first time that I've dealt with a record request that got converted to a client record request, but in the way that this request was submitted, yes, this was my first time navigating it in this way with language like this. I'd also just add, though, again, in trying to filter between the requester requesting records to someone that would have a public persona, I think that would still be on us to work with them to figure out that they are who they're claiming to be. Again, especially if the name is something that there's more than one individual in that system, and then all the data points that they're referencing being related to communications still hinge on services that we provide. I think that's also clear, but I do hear what you're saying, and I'm taking that into consideration.
Then let me just ask one last question. Where do you find the authority in law or whatever that you can convert a request that you just said from a public records request to a client request? I'd love to hear about that.
Yeah, no, again, this was guidance that I've also received with communications with our privacy office team, as well as our local city attorney, that it would be best to handle this as a client record request because it hinges on seeking records that pertain to a client who's receiving services from HSH.
So is there any law that you can point to that gives you the authority to do that, or are you just doing it?
The HMIS technical data standards.
I have kind of a simpler way, I think, ask what he's asked. Let's just do a real simple hypothetical.
Yeah.
Let's say there's employee A and employee B in HSH, okay? Employee A emails employee B an email that says, Aaron Wilson called 3 times today. He seemed really grumpy. That's the extent of the email. And then me, I'm not Aaron Wilson. I say, I want any emails or any records with Aaron Wilson. Would you give me that email? Again, all it says is Aaron Wilson called 3 times today. He seemed really grumpy. And no offense, Mr. Wilson, I'm not saying you were really grumpy. I'm just,
Okay.
I think this is the spirit of what you're saying, is people are sending gossipy comments amongst themselves. I think that's kind of what you're getting to. There's nothing in that email that at all says that he's a client. It could be you're the pizza delivery guy. It could be Aaron Wilson is a manager. Who knows whoever, right? Nothing in that hypothetical identified him as a client. So my question to you is, if that email existed and I requested it, would you give it to me?
I mean, prior to even making a decision to give it to you, I definitely would consult our local city attorney. I definitely would talk to our privacy office. I've not received a question or record request similar to that. I think requesters are pretty clear on whether they want records because they are a client or they're receiving or requesting records on behalf of a client. I've not dealt with a situation such as that. So I would definitely consult our city attorney and our privacy office before making a determination.
Okay. I have Member Schmidt and Member Kumar.
All right. I'm going to sort of switch gears a little bit. First, I'm going to ask the respondent. You said that in your department's records, there's more than one Aaron Wilson, correct?
Correct.
Okay. How many?
I can check and get that back to you, but last we checked, I think there were at least 3.
At least 3. All right. Did this requester give you any identifying information at any time other than name? Just the name Aaron Wilson.
In the context of the records request.
In this requesting time where we're talking about requesting records.
Can you ask that question in another way, please?
Yeah. You've got a name, Aaron Wilson. You've got certain records on that have some connection to people with that name, correct?
Correct.
Okay. And with the request you've received, are you at this time able to determine which of the documents that refer to the name Aaron Wilson pertain to this requester?
That's what we have not verified. They've indicated that they were the only person at VVTC, which I think is also relevant to the request that was made. But again, we've still not verified that this requester, this Aaron in this instance, is without a doubt that individual. And so we've treated it as though it could have been a request made by anybody in the general public.
Okay, so those 164 emails, I'm just using the number because that's what I wrote in my notes. They could pertain to any of the Aaron Wilsons in your database, or it could be some other Aaron Wilson. Is that correct?
The way that we were trying to identify the client is specific to the request that they made. However, the scope of the request still remained intact. So the records that we pulled all relate to an Aaron Wilson with respect to Bayview VTC at HSH, Urban Alchemy, Bayview Hunters Point. They're not attached to just Aaron Wilson more generally in any other instance.
Okay, so the emails that you haven't given, you think that they generally would relate to the person who's Aaron Wilson, who's describing themselves in the correspondence that you've received pertaining to Bayview, correct?
I would hope so. We're just seeking to verify that.
Okay. Now, the 164 emails, you consider those to be within the scope of the federal protection, along with any kind of personal records of this Aaron Wilson that are maintained at your agency, correct?
Correct.
Okay. And so but you didn't give this requester any documents, even documents that would have a lot of redactions, blacked out areas, correct?
Correct.
Okay. But I think this may be my last question. If this Aaron Wilson were to submit to you a client request form, would that allow this Aaron Wilson to get those emails produced to him?
100%. We've said that in multiple ways. I've said that more than once. Our privacy officer has said that more than once. And then for the record, they would be released to the email that was set up in next request pursuant to this request specifically. So if it's connected to the petitioner, which I'm hoping it is, those records would then be released to them effectively.
Okay. And it's your understanding that the protection, which is, I believe it's federal, is a broad protection to protect information about people who are clients of your agency.
Correct.
All right. Thank you. That's all.
Okay, Member Kumar, and then I think we should, then Member Hood.
This question is for the department. So when you determined that these documents are, they are going to be reclassified in another category, why was Mr. Wilson not informed of this change?
Oh, Mr. Wilson was informed of this change. I think before we even closed it out in next request in a timely and complete manner and matched that out, I provided him a fillable client record request form. I outlined the appropriate inbox for that, where it should be submitted. I connected with our privacy officer in advance. I worked with them. I provided a warm handoff shortly thereafter via email, very clearly outlining that if he were to submit the client record request form to that email inbox, that they would receive the records that we pulled and reviewed in a timely manner, almost immediately at this point. That was all communicated to the petitioner very clearly and also laid out in my supplemental materials.
Mr. Wilson?
Yes.
At that point, when you received this communication from the department, did you accept that these records had to be reclassified?
No, I kept telling them in the email stream there at next request that I'm not looking for my personal records all the way through. So no, I felt that was a diversion. And with respect to identifying me, Aaron F. Wilson at Proton Mail is what I use for this login here. It's what I use for next request. It's what I've used for every communication between HSH and myself, Bayview Foundation and myself, and Urban Alchemy and myself. I only use one email. So you could verify me with that fact alone. It's replete through everything I'm doing. So he said he tried to look it up through that way, and he said he didn't find me. So right there, it's like a Perry Mason moment. So, I mean, it's just ridiculous. I am Aaron F. Wilson. That's at the VTC. There's only one, and my email is consistent through all communications to the parties involved here, including this body here with Patricia. It's all Aaron F. Wilson at protonmail.com. Only one email, Aaron F. Wilson at protonmail.com. That's it. Next request, this body, HSH, Bayview Hunters Point Foundation, and Urban Alchemy. So they could have verified it through that. And I'll show you my ID right now if you like.
No, you don't have to do that.
Okay, I'm cooperative.
Any further questions? Okay. Member Hood. And then real fast, because you already had one go around.
Two things. Mr. Robinson, did you, as part of your search, did you do a search for that email address and did it return any records?
Correct. We've also communicated this to the petitioner. Our privacy office did conduct a search in our one system in alignment with the email that was provided for this request, and there were no matches.
Well, that sounds like it's in that conflicts with what the petitioner just said, that Mr. Wilson said he has been communicating with you. So you're saying that prior to this complaint, your department had not received emails from that email address?
The source of the emails and the communications that we've had pursuant to this request have been consistent. We're saying that the email for an Aaron Wilson in our database, one system, does not match the emails identifier that was made for the request.
Oh, I'm not asking about the one system. I'm asking about in the city's email system. If you look in the city's email system, are there any emails from that address? So if Mr. Wilson had emailed you or anyone else in the city directly, would that email address appear?
Yes, and it did appear. I think, again, it still turns into a matter of the requester asking for records persistent to them as a client. They said they were the only one at the baby VTC, which is why, again, we were trying to verify that. But yeah, the email communications were consistently received by the same email address, yes.
Do people in your department sometimes share news articles that are relevant to your work?
We do have like an email blast that does provide that information internally, yes.
So as Mr. Wilson has indicated, he is kind of locally famous. If you Google Aaron Wilson Bayview Vehicle Triage Center, he's quoted by CBS News, the San Francisco Chronicle, the San Francisco Standard, actually twice by the Chronicle. And these are all recent articles, ones that I imagine might have been shared by people in your department. Now, granted, if the whole text wasn't forwarded, it might not have appeared. But if anyone other than Mr. Wilson had made a records request saying, I want to see communication within HSH about these articles, either including the links or further discussion on the articles, would you have returned those? And if they mentioned Mr. Wilson by name in the text among staff members, would you still have responded to the records request with those emails and perhaps redacted his name?
I would always respond to the record request. At first, I would do a search to see if we have those records. I can't immediately speak offhand and say, yes, we have these records that have been internally circulated. But then once it's determined that we do have those records, we would still review them for client information. But I think we would just release them if they're seeking just the newsletter itself. But in this instance, that didn't apply. And then I can also just add, for the sake of the review of the records that I did review, that were responsive to this request, that were produced from our staff, those were not a part of the records that are being held at the moment.
Okay, thank you. I appreciate it.
1 minute.
Yeah. This is Member Pilpel again. I don't understand this homeless management information system, but I'm not going to take the time right now to try to understand it. I do believe that some amount of HSH's records involve clients and are properly subject to client privacy and disclosure. But I don't believe that that covers all of your records. Would you agree with that, Mr. Robinson?
Can you repeat that for me again?
Do you believe that all of the records that HSH has about everything under the sun, that all of that is subject to the same client privacy standards, or only those records that relate specifically to clients?
I would say only the records that relate to clients, which would apply in this instance. And I'll also add, for the review of the records that we made, there were other clients referenced in this record request that were redacted.
That's fine. So I think some of us have asked this in a couple of different ways, but by way of example, if Mr. Wilson, myself, anybody else wrote letters to the Board of Supervisors or the HSH Commission or the MTA Board or the Planning Commission or any number of city departments on any topic under the sun, that would be subject to disclosure. It's a public record, right? And if you're asking for a search term, if it's search for Aaron Wilson and any communications at the Board of Supervisors in the last 6 months, that would either turn up records, which would be subject to disclosure, or not. I think essentially that's what Mr. Wilson is asking in, a much more narrow and specific way. he's made abundantly clear to us, and I thought to you, that he's not looking for.
Question?
Yeah.
We can
Do you
move to deliberation next.
Okay. Do you, I think I've already asked. I asked earlier, maybe I'll just try one more time. Do you not have a way to distinguish between client protected records and general purpose records that are subject to disclosure?
We do. The privacy concerns were triggered in this request because they indicated that they were a client seeking records about themselves.
But he disclaimed that. Okay. All right. Never mind. Thank you very much.
Okay. I think we're ready to move to rebuttals in this one. So let's go ahead and we'll start with the respondent. It'll have 3 minutes, and then the petitioner will have the final 3 minutes. And our administrator will let you know when you can begin.
Mr. Robinson, are you ready?
I am.
Your 3 minutes begins now.
Thank you. We really don't have any rebuttals. I believe we've covered this pretty thoroughly, and I'll add that we really do our best. And in most instances, I'd argue we go out of our way to find solutions to get the requester what it is that they're looking for in a timely and complete manner, which I also believe we did not violate. Thank you.
Thank you.
And the petitioner?
I think you guys asked a lot of good questions about this matter, and I really don't have anything further to say. That I'm probably going to be seeing you again, and Tavares as well, because he's let the extension expire without producing another request I made. So look forward to seeing him again and see how he explains his way out of that one. But I pray that you'll find for me and what I'm asking for, and I really do appreciate your panel's thoughtful questions of this respondent. Thank you.
Thank you.
Okay. Thank you, Mr. Wilson. Okay. I want to proceed on this one. Do you want to continue your line of thought now?
I'll just open very briefly. I'm feeling a violation here. I appreciate that HSH is concerned about client privacy and confidentiality, but I think they're taking it too far. And I think they are not distinguishing in this case between client records that need to be handled in a client record kind of way and this public persona thing that I just created as a thing. Because I believe Mr. Wilson has been very clear that he's looking for records related to the name Aaron Wilson. And frankly, it could be that Aaron Wilson. It could be one of the other 2 or 3 Aaron Wilsons. It could be any old Aaron Wilson. Just, do a search for Aaron Wilson involving the Bayview Hunters Point Foundation. I assume that would turn up something. And if it's subject to some kind of redaction that's appropriate, then redact it as appropriate and disclose it. But to say he can't have anything unless he's willing to, provide his information for verification as a client, I think goes too far. And in this case, he's not asking for his client records, So I'm feeling a 67.21 violation at a minimum. And I period.
Yeah, personally, I agree with you. I'm very concerned. This might be a tactic, particularly since it's obvious, as Member LaHood found, that this is a public person in some way. He's been quoted numerous times in the media. The fact that a city department could conceivably have extensive conversations about someone who's a public, to a certain degree, a public figure, and then somehow try to invoke a health or customer type of exemption on that just seems totally misplaced. As Member Pilpel said, I think needs to be a much better job of delineating between what's, a health or customer service type of or client service exemption versus just discussing anyone. It could be any Aaron Wilson. It could be, like I said before, it could be the pizza delivery guy named Aaron Wilson. I think all that has to be disclosed. You don't get to, just, at least my opinion is that you don't get to do that and just withhold any discussion, any gossip that you have about someone just because they happen to be a client. That doesn't give you the right to do that, to and I'm not accusing you of gossiping, but let's just say you had, or anyone in your staff, I don't mean you in particular, Mr. Robinson, but you as HSA were to do that, I don't think that gives you, you can just use that exemption. And I see Member Schmidt, Member Kumar. And then Member Wolf to that.
With due respect, I'm on the other side on this one after hearing everything I've heard. I believe that the efforts that are made to protect records about this population that do receive, I believe, pretty broad protection under the law. I have to commend those efforts. And I think that items that specifically refer to someone who is a person who is within the protection, I think that it's reasonable to construe that those would come within the protection. I also want to just say that if a person not named Aaron Wilson were requesting emails about Aaron Wilson at the homeless department, I believe that Aaron Wilson would have a potential claim for a violation of the protections that Aaron Wilson is entitled to if those records were disclosed to that other person. And that's sort of what I think would make these not public records. So I understand that I may be in the dissent here on this, but that's my feeling. I think they're trying to do what they can to protect here, and I don't see a violation.
Member Kumar?
I'm with Member Pilpul on this one. I agree I think as well that there's a violation of 6721. And I think this case might send a dangerous precedent for other departments to reclassify information under, protection under federal law or other categories just because, they don't want to release that information. I think it's, should find a violation, and we should also leave a comment for the department that they release the information to Mr. Wilson immediately.
Wolf. Oh, Wolf. Yes, right. Yes, Member Wolf.
Yeah, I was going through some of the citations the respondent used as a defense against releasing the information. For instance, in Admin Code 67.1G, it speaks to entities. This person is a person, not an entity. And in California Government Code 7927.7, that is listed under Chapter 3, which is about environmental protection, building standards, and safety requirements, which has nothing to do with the substance of this request. Also in the California, they also cited California Constitution, Article 1, paragraph 1.3b, and that's relating to public comment, not necessarily public records. So I don't know. I'm not that I haven't finished going through all of them, but I'm not quite convinced that the request for information about a person by name, let's go under redaction. The rules of redaction doesn't necessarily remove the person's name unless they actually are in danger or found to be in danger in that kind of thing where it's known. Otherwise, I don't necessarily see I don't see why there would be this issue, or even taking under Member Pilpel's suggestion that of the conversion from a public record to a client record. The other thing is they also cited admin code chapter 12M as in Mike. And in there, it specifically says, the city shall not disclose private information to any person or entity unless specifically authorized to do so by the subject individual. And I think Mr. Wilson here has plainly done that. I think that's very clear. And there's nothing else in that section that I can see that, because it's mostly focused on contracts and entities other than the actual sharing of information with a person. So I'm leaning in that direction. Thank you.
Okay. Thank you, Member Wolf.
So we may have a motion and a divided vote. Prior to that, DCA Shapiro, did you actually have anything to share that might illuminate for us? The answer may be no, or whatever. It's up to you.
I've been looking through the statutes that are set forth in the record that are the basis for withholding, and I would need a bit more time to see whether any of those apply. Those that I've looked at thus far, I can't say would necessarily apply to the extent that there are emails in the possession of the department that pertain to this individual, but do not pertain to the provision of social services to this individual. And to the extent that those records exist, my initial impression would be that they would be public record subject to disclosure under either the PRA or the Sunshine Ordinance.
Possibly with some level of redaction and all of that, but subject to disclosure. Okay, thank you.
I think the only concern I have in this case, we've kind of figured out how we move forward, is it sounds like there's 164 potential emails. Right?
Yes.
And we don't know what buckets, or silos that these fall into, right? I would be hesitant to say that, he needs to turn over all 164, because some of them actually very well may be in the realm of a client or a service provider. And there may be other ones that are just the type of emails we were just discussing, right? And that's one of the, I think, the limitations that we have is we can't see all those emails and then say, okay, these 15 or these 20 are ones you should disclose, the other ones are not. So I'm just kind of struggling with the best way to move forward on this. Member Hood?
I mean, I think it would be fair to say that I think we would like the department to do another round of review on this and come back to us and recommend that if there are emails that are clearly do not have to do with providing of service, and maybe our discussions of articles that appeared in the media about, these issues, where Mr. Wilson is mentioned either by his full name or clearly by first name, referring to the specific, this person who is being discussed. I think those should be released.
If we were to, let me think of it this way, for those, and I know not everyone's in agreement, and I don't know where everyone stands on this, but for those who are leaning in that direction, if we were to make a motion, it's kind of weird. I'm not sure I want to necessarily make a motion to find a violation yet, because
we don't
all
know.
164 might be in without seeing them, right? I mean, it's almost like I want to, make an order before we make find a violation. Like, have an order that they either classify them as like client service protected, and if none are client service protected, to release those.
Could we without making a decision, refer this to CAC with a request to the department to review them again and see if they can be divided into two categories. And if they come back to us and say, no, everything falls in the same category, although I would be surprised if there are not just a few that don't fall in that category.
Mr. Robinson, if we were to ask you or your department to classify the 164, whatever emails there are, that you think may be potential responsive records to this, and to classify them as either a client service provider based email or one that just happens to incidentally mention Mr. Wilson, not directly related to his, relationship with HSH. Is that something you could do? Could you come back and tell us 20 of them fall in this bucket, the other 144 fall in this bucket? Or whatever the numbers happen to be. You might need to unmute him, Pat.
Can you hear me?
Yeah, we can hear you. Yes.
Oh, awesome. Yeah, no, I'm definitely happy to go back and do that. Again, I'll add that I've reviewed them. Our privacy officer has reviewed them. And from what I recall, like the bulk of them, if not all of them, did relate to client service provider based communications. But again, I'm happy to go back and do another review, but that was my sense.
Even if it's a small number, if it's 2, if it's 4, if it's 5 that aren't about client services, we would want those to be turned over.
Okay.
Thank you.
Yeah.
Okay, so I'm going to try to make a motion on this. Feel free to, if anyone has input on this, I'm going to do this without finding a violation. And this is kind of an odd thing that we do, but I'm going to make a motion that the Department of Homelessness and Supportive Services,
Supportive housing.
I'm sorry, Supportive Housing, Department of Homelessness and Supportive Housing, examine the potentially responsive documents, classify them as whether or not they relate to client services, and order the production of any that do not fall into the client services umbrella, we'll call it. Category. Client services category. And further refer this to the Compliance and Amendments Committee for follow-up. So I think that does it without finding a violation, and then we can see where that goes. Kumar, do you have-
So I just wanted to confirm we are not finding a violation?
My motion does not, because I don't know if all of them do or do not fall into this client services category, but we could always come back and we could find a violation. But without knowing that, I think that, to me at least, it's prejudging. I don't know, based on the testimony, whether or not some of these are or are not disclosable. But
Yeah.
others might agree. Disagree.
I just say, I understand your motion, but I still think I find a violation, even if it goes to the committee. It most probably will come back, but at this point, I do see a violation, and I think for me, the right way forward would be we say it's a violation, it goes to the department goes through the documents. If there is something so extreme that they cannot share, or there's a reason that they cannot share, then they have a good justification for it. And if the case comes back to us, then we obviously go through it. But at this point, for me, this is the right way forward. But yeah, I most probably will not vote for this motion, but just wanted
Totally understand. And if you want to make a motion after I'm just not comfortable doing that with my motion. You can absolutely make that motion, but that's going to be my motion. I don't know if there's any seconds or not. But
I'm thinking about whether or not to second. I'm inclined to go the approach that you're using, but to add the violation, because my feeling is that this is what they should have done to begin with. And I'm starting to question why this whole package of email, if all it is email, couldn't have been released with lots of redactions. Any sentence that says, you're getting services, or your complaint about services will be anything that's client focused, I think can be properly redacted. But and I don't know how much of that is there. I'm not looking at any of this in camera or parsing it out, but that's the whole point. That's what the department, in my view, should have done. And so there may be a lot of redactions to be made, but I'm failing to see why there shouldn't have been any disclosure. That's why I'm thinking that there's some violation here.
I'll get you to say, just my response to that, why I'm not comfortable with that. If I ask for emails that have Matt Yankee in them, let's say, and you give me something back, and every instance where it would say Matt Yankee, it's now redacted. You could put two and two together now and see that every blackout is where my name would have been. To Member Schmidt's point about potentially leading down that road, I do appreciate the fact that certain things may need to remain confidential, and you can't even put the pieces together. But
I guess I would have done it differently. I would not have redacted the name Matt Yankee. I would have redacted the rest of the sentence.
Oh, just so it says Aaron Wilson, and who knows what it's about.
Right.
Yeah.
So, if it's Aaron Wilson showed up last week at a Board of Supervisors meeting, I think that's public. If it's Aaron Wilson may or may not be eligible to receive benefits, then it's Aaron Wilson, and then the rest of the sentence gets redacted. That's how I.
Member Sugarman?
I was just going to say that I agree with that, and also that if this is referred to compliance and there is emails where it's like, you have a mixed case scenario, it may just all be flagged as client privilege and not be able to see any of it. And then
I think that you could probably redact part of it, the part that would be the client service. And
I just mean, I understand. I just mean the nature of the order. If that happens, then you might still have information that's worth seeing, and then we wouldn't know that if you just said, oh, please find us those emails that don't have, any client, privileged information in it. And they're like, well, they all do. So they're all.
Yeah, I'm happy to reword how I did it. Did you read it back? What you have?
Moved by Chair Yankee that the Department of Homelessness and Supportive Housing examine the potentially responsive documents, classify them as whether they relate to client services, and produce the emails that do not fall into that category, and further refer the matter to.
Yeah, I see. Okay. I see what you're saying. So there could be some that are mixed, right? It could be some that. Right.
And they would be interested in protecting
part
those.
That's not.
Yeah.
I'm into the redaction.
Yeah, I agree.
Appropriate redaction.
And something that and for maybe if I add, let me know what you think. And for those that do fall into the client services category, to release any portion of the email that is not related to that category.
Yeah.
Would that?
Yeah.
I think
we're getting there.
Yeah. Okay. Member Kumar, go ahead.
I want everybody to make note of the fact that the department did say that there are multiple Aaron Wilsons, and it's been difficult for them to figure out which one. First of all, I would like to say, if they do have a database of people, if there's just one email being used by Mr. Wilson, it should be very easy to pull up who he is. Of course, I'm not discounting the fact that a lot of people might have the same middle name and it might have the same whole name. But in this particular case, the department has clearly said they are unable to identify who the person is because there are multiple Aaron Wilsons. So we should also, I think, somewhere down the line also consider the fact that they might come back to us again saying that we can't find the person, we don't know who the person is. There are multiple people with this name and there's confidential information in that. The department needs to figure out whether the person who has petitioned has communication that are under attorney-client privilege that have to be redacted. If that person doesn't have any communication that has to be redacted or that is confidential, then that information should be shared with the petitioner. That's what my view is.
Okay. Member LaHood?
Yeah, one last thing. I would like to point out that this course of action, which Chair Yankee is recommending, does not preclude Mr. Wilson from also providing identifying information that would release all of this information to him, which might provide him with evidence as to whether his initial request was satisfied or not. So it behooves the department to follow through with our request and release any information that would not need to be withheld because it pertained to services being delivered. And it would be to their benefit, I think, to release those because Mr. Wilson may come back and receive everything and would be able to come to us and with sort of the distinctive categories.
Member Schmidt?
Yeah, I would not support the current motions that are being discussed, but if Chair Yankees was made a little more specific, I think provision of client services is not quite good enough for me. But if we gave the department not the directive of client services, because I'm not sure where that terminology comes from, but instead were to give the department the ability to refer to the actual federal extent of the protection, which may be different. It could be less or more than client services, but I think that they legitimately should be looking to what the federal law extends to. And I think that might include a little more protection for identity, like documents that include the name of a recipient. So I'm listening to what people are doing here, but that's just sort of my thinking about how the thing should be written.
What does others think? I don't want to be too restrictive that we end up coming back here with them just requoting the same federal guideline without relating it specifically to the emails. But at the same time, absolutely point taken. I certainly don't want to ask anyone to release something that is federally protected. I just don't think that separating of the two has been done by the department, because I would ask them questions. If I asked, called and said, did Aaron Wilson call 3 times today and did you find him grumpy? And they said, that has nothing to do with client services. Who cares for that? I mean, it could be any random person on the phone. And I want to make sure that we don't also, allow departments to invoke exemptions where it gives them a free for all to do whatever they want with internally, right? I mean, some things I think should be made public and don't have those protections. I think they're overusing the federal one. So I'm interested if you maybe have any more guidance on how that federal guideline.
Well, I think that I agree with you that what we're going to ask them to do is go back through and with in mind either the category that was client services or what I was suggesting is with in mind what the federal law says. But either in your case or the language I was suggesting, that they had to go back through those emails and take that standard, whatever standard we give them, apply it to those emails and do a redo and determine what is outside the scope of what we tell them is the scope. So yeah, they're going to have to do an application of the law to the facts here. Agreed.
What if, I don't know if everyone's thinking about this, what if I said everywhere it says client services, we said client services or other legally protected category, and then it's up to them to define legally protected category.
I'm good with that.
Okay. Is that?
I heard Member Wolf saying it.
Member Wolf, go ahead. I'm sorry.
Yeah. I think, it's one thing for a respondent to make citations of law, but they also need to provide some subjectivity to it as to why they're citing it, what that kind of makes their case, which we haven't heard from and I haven't seen in writing. So there are, having been a social worker for decades and having seen these laws inside out, and I know they've been updated here and there, and rereading some of them, there are very specific aspects to confidentiality as you're trying to work your way through this. You know, for instance, there's a discussion around continuum of care. And the question then becomes, is the subject of this matter receiving quote unquote in caps continuum of care assistance? I think that case needs to be made. There are other such very specific aspects that all the laws that were cited point to, and I think that that bar has not been made yet. So I think you're on the right track to have them, you know, kind of go through each of the laws that they are citing as protections and applying, as Member Schmidt is suggesting, applying those filters to this particular complaint.
Thank you,
and to
Member
the records that are being asked for. Yeah, thanks.
Member Popo.
I think the most recent formulation that I have is either ordering or requesting HSH to examine potentially responsive documents and ultimately to produce any non-client service or other disclosable record or portion thereof. And where I'm not sure that we have broader agreement is whether or not to find a violation. I think the only way that we order them to do that is if we find a violation, and otherwise I think we're just making a request. And I think if we believe on balance that they should do this, that they should have done this, whatever, then I think there's a violation. And if not, then I think we're doing something unusual for us. Not that we can't, but it becomes more unusual.
Agreed, it becomes unusual. But I thank you for summarizing it. I think that's perfect. So we can make sure that if that's what I'm going to stick with, and maybe we call it a request if you're uncomfortable with using the word order, but it might be at the end of this exercise that all 164 truly are, exempt from disclosure. I'm not saying we don't know. So I can't. For me, I have a hard time finding at least a violation of 6721. I mean, arguably, maybe they should have done a better job justifying the withholding, and it could be a 6727 violation. But they did quote the laws. I'm just not convinced that they.
I suspect that they're either all or most are subject to disclosure, but probably with plenty of redaction. So I think the problem I'm having is the blanket non-disclosure, the blanket withholding. Right. And it seems to me like they're applying a standard that we wouldn't hear articulated by the fire department on fire incident reports, the police department on police incident reports, the health department on patient records, HSA on client records, et cetera, et cetera. All the employees about employee records that they've created this thing that is not consistent with the way we deal with specific records, which is generally disclose and redact. And it's much more unusual that an entire class of records is held and only produced and treated as a client record. Especially when the requester has expressly said, I'm not looking for my client records. This is what I'm looking for, is the email about me and back and forth.
Like to that's why I'm maybe call the question or something.
That's why I'm leaning towards including a violation, but you wouldn't go that far.
I'm not going to at this point. Okay. Can you read what you have and then?
Yep.
So Pat, this will be what my motion is,
or some version of it.
Yeah.
HSH to examine potentially responsive. You had documents, maybe we'll just say records. Potentially responsive records. Produce any non-client service or other disclosable records or portions thereof.
Yep. That sounds good. And refer to CAC for monitoring, and then you can bring it back. That's going to be my motion to move things along. So,
Second.
okay, so seconded by Member Wolf.
I'll be opposing because that didn't include any language about any other law. And,
I'm sorry.
and that's
No, no.
no, you didn't say it.
Okay.
I said, or other disclosable record. So for whatever
doesn't-
reason,
No, the language you said was you could disclose any disclosable record. That's actually kind of like, I don't know what that means.
Okay, yeah, okay.
do you want to reword that?
Peck, I'm sorry.
So close.
Motion
Yeah.
by Homelessness and Supportive Housing to examine potentially responsive records, produce any non-client service.
Or
Or those
other-
not otherwise legally protected
that's fine.
from disclosure.
And I think we mean and.
Yeah,
Yeah.
Or any portions, and there was something about, or any portions of them.
Just a moment, please.
Do we need to say that they should cite, they should spell out the rationale or their interpretation?
I think that's understood.
Okay.
Yeah.
I don't disagree, but I think it's understood.
Yeah. That would be the expectation when they go to CAC to explain where they're at.
I think I may have missed something. Motion by HSH to.
No, it's motion by me, not HSH.
Yeah, by Chair Yankee, that HSH examine potentially responsive records, produce any non-client service and those not otherwise protected.
Legally
records.
protected from disclosure, not legally protected from disclosure.
Don't think I've said legally. Okay. Produce any non-client service
Records, or those otherwise legally protected from disclosure. And then something about disclose the portions thereof.
Those otherwise.
or those not otherwise legally protected from disclosure.
Or portion, what was the part you had?
Or portions thereof.
Or portions thereof. So in other words, you need to find if the entire thing or a portion of it doesn't fit into client services or some other legally protected, exemption. And if they don't, then they need to tell CAC or, they need to just disclose them and then explain it to CAC what they didn't disclose and why.
Right. Redact, explain.
Right, yeah.
Yeah.
The or in there is somewhat confusing to me. I wonder if we could instead say non-client records that are not otherwise.
I'm
Yes.
fine with that.
Yeah.
I like that better. I like
Okay,
that better.
okay.
Yeah, I'm totally fine with that.
Motion that HSH examine potentially responsive records, produce any non-client service records or non-client records.
No. What did you say, Member Schmidt? That was perfect.
I think I heard non-client service records that are not otherwise legally protected.
I need someone to start from the top, please.
HSH to examine potentially responsive records, produce any non-client service records that are not otherwise legally protected from disclosure.
Or
Can I
any
introduce-
portions thereof.
There.
Can I introduce one more thing? In ahead of the word produce, in order to produce. So we're asking them to review.
Oh, yeah, in order.
To produce.
In order to produce.
And then everything else.
Yeah, or any portions thereof. Which I think is to Member Sugarman's point about protection. Okay.
We got a word wrong, you can finesse it, but I guess
yeah,
you've got enough word salad there.
Well, that's good, Pat. If we need to work on exactly the semantics of it, we can do that afterward. I don't want to hold it up any longer. And the CAC referrals.
We'll vote on the motion or the portion thereof. And for email it on Proton Mail.
Okay, is that moved by Chair?
That was me, yeah, and then seconded by Member Wolf.
Is the zoo still the big elephant in the room?
Okay, any public comment on that?
Anyone wishing to make public comment on item 7, please approach the podium if you are in the room. If you're in the online community, please raise your hand in the app or press *3. Give you a moment. We have no one approaching the podium, no one in the queue.
Okay, we'll close public comment. Take a vote.
Whether they like it or not, do both parties understand the intent?
Yeah, that's correct. Mr. Wilson, Mr. Robinson, do you understand what we're asking? At least with
yes, and I thank you for your
If it passes.
deliberations.
Okay. And it's clear to you, Mr. Robinson?
Yes.
Okay.
Thank you.
Great. Okay, so we're going to take a vote on this, and if someone has other motions, we can deal with that. But let's move on. So.
Taking the vote, Chair Yankee.
Aye.
Chair Yankee, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
No.
Member Kumar, aye.
No.
Member Kumar, no.
No.
Member Anderson.
Aye.
Member Anderson, aye. Member Highland.
Aye.
Member Highland, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Vice Chair Stein.
No.
Vice Chair Stein, no. Eight ayes, 2 noes.
Okay, so that motion passes. Are there any other motions? Seeing none. Okay. That item is done. Thank you to both parties. We'll be in touch regarding the follow-up hearing. So let's go ahead and move on to item number 8.
Thank you very much.
Thank you.
Yeah.
Item number 8, file number 24066, complaint filed by Justin Barker against the San Francisco Joint Zoo Committee for allegedly violating Administrative Code Sunshine Ordinance, Section 67.15, by failing to provide an opportunity for members of the public to directly address a policy body, and 67.16, by failing to record the minutes for each regular meeting of the board or commission. On January 21, 2025, the Complaint Committee, moved by Chair Schmidt and seconded by Member Stein, referred the matter to the full task force for a hearing to consider a Section 67.7D matter regarding comments made during an item appearing on the posted agenda, 67.14A regarding the right to attend a meeting and record or broadcast proceedings, and 67.15C regarding time limits allocated for public testimony during a public comment period.
Okay, and do we have the parties here? Mr. Barker, okay, come on up. And is there anyone from the Joint Zoo Committee, either online or in person?
Rec Park or the Zoological Society?
Yeah, whoever's going to be the respondent.
We have no one online and we did not hear from respondent in advance of the meeting.
And Mr. Barker, it appears you're online as well. That's the first time I've seen
goodness.
both. Okay. So we do not have a respondent, and I don't believe the respondent showed up to the committee hearing, but I will turn it over to Chair Schmidt to kind of give us a summary of what happened there.
Yeah, this joint zoo committee, we didn't really get any information from them as to how that works. We did from the petitioner described it, but we didn't really make any kind of determination whether there's a jurisdiction question or not. We just sort of left it because we hadn't heard from the Joint Zoo Committee. I don't know if it's a, if it's subject to Brown Act or not. I'm assuming it is for the time being, but we left that open. Member Stein made a motion that we do need to look at that question, jurisdiction, and also to consider potential violations. The three that are listed, and the one that was a little less, I guess, hard to determine is the one that asks to evaluate whether the notes from the hearing were accurate in terms of like describing what happened at the hearing. That was a little bit more nebulous than the other ones. The other ones seemed a little stronger. Okay. Member Stein, was there anything to add?
Yeah, I'll just add that we were just making recommendations rather than any decisions, or not strong, making recommendations to consider things rather than recommendations to rule a certain way, because at the time we also didn't have as much supporting documentation as the petitioner has since provided, and we asked for a lot of specific things, and as I look at the packet, I think most of them were provided. So I want to thank the petitioner for that. I think it should be easier to make determinations on some of these questions, given that we have more information.
Okay, so we'll go ahead and get started. You'll have 5 minutes to make your case, and Administrator Peterson will let you know when you're ready, or if she's ready.
Are you ready? Your 5 minutes begins now.
Thank you. Hi, my name is Justin Barker, and I run San Francisco Zoo Watch. You can find it at sfzoo.watch. It's a site dedicated to uncovering the issues at San Francisco Zoo. And if you've read the news in the last 6 months, there's a whole lot of issues at the San Francisco Zoo. Corruption, nepotism, exodus of staff, public safety, animal neglect, and sadly, so much more. And tonight I'm lodging a formal complaint against the San Francisco Joint Zoo Committee for Sunshine Ordinance violations, particularly concerning the public's right to record meetings. The committee is co-chaired by Larry Mazzola and Kat Anderson from Parks and Rec, and they have shown consistent bias towards the Zoological Society in these meetings, compromising the expected neutrality of an oversight body. Notably, on November 21st, 2024, Mazzola ordered ABC 7 News to stop filming a public meeting. And on December 19th, Anderson threatened to eject an attendee for recording, both clear breaches of the ordinance protections. Additionally, co-chair Kat Anderson, documented in the October 2024 minutes, has spoken up during public comments on non-listed agenda items praising the zoo. And one of the other concerns I have is it's almost impossible to find the meeting dates, draft agenda items, or the archive minutes for this committee. And specifically around the minutes, The minutes are managed by the zoo director's assistant, and they frequently distort or omit critical public commentary, failing to meet transparency standards. This bias in record keeping and selective enforcement of the rules highlights a really disturbing prioritization of the Zoological Society's interests over public accountability. And tonight, I really urge the Sunshine Ordinance Task Force to investigate these issues and thoroughly uphold the principles of transparency and accountability. Thank you.
Thank you.
Thank you.
Vice Chair Stein, you want to take over?
Oh, sorry.
You're the pilot.
So we need to hear from we don't have a respondent here, is that correct?
Right.
Okay, so
Correct.
then we move on to any questions that anyone might have for the petitioner.
So hi, this is Member LaHood. This is just in response to the last thing that you said. Where did you look for, you said you had trouble finding announcements of the meeting and the minutes online. Where did you look?
So there's kind of like if you actually like search Google and search the Joint Zoo Commission, it will like have an item, but the last time it was updated was like 2019, 2021, something like that. The way that it kind of has been buried is when you go through the kind of archive of records. It's like within commissions, it's just like severely buried. So without, I've regularly look at these records, and every time I go to find them, it's really a challenge to find them. So I don't know if that's intentional, if the burying of things is intentional, but it makes it really challenging for the public to actually say, here's this meeting, here's how to attend, here's what went down in that meeting.
So I just did a search, and maybe it's because I don't know as much as you do and sort of did a quick thing. I did find these documents online, but you said Joint Zoo Commission. I found them online as Joint Zoo Committee.
Committee, correct.
So I'm looking at sfreckonpark.org/document center/index, and I do see meeting minutes from, assuming this entity meets quarterly, for the past several years.
Mm-hmm.
And I am finding those online.
They're all there. Like all the minutes are there.
So they are there.
They're there.
Okay.
It's just that the fact that it feels like it's not like readily available on, it doesn't feel.
That's the story of the city of San Francisco.
Fair.
I hear what you're saying,
Yeah.
but I mean, this is not special to this committee or this department.
Okay.
And but okay, so you have found these same things.
Yeah, sure.
Okay.
Certainly, if I dig, I find them.
Okay. I'll let somebody else go. Thank you.
Member Bilpel. So a few things. Let me go to the notice issue first. So this was heard at complaint a few weeks ago. It looks like Ashley Summers was notified. Tanya Peterson was notified. I don't know who this Ann
Executive Assistant to Director Peterson.
Got it. So they all knew and did not attend either complaint or hear and sent nothing. Is that correct?
They were informed whatever's in the packet is what we received.
Okay. Can someone point me to anything?
I didn't see anything. I was
from
looking
respondent.
I
Okay.
think there was something very briefly, a response from someone from the zoo in the next case that we're going to hear.
Okay.
But nothing for this one. And I do want to point out too that what we have here as respondent supporting documents in this packet is actually additional materials that were added by the petitioner. So those are the petitioners supporting
Okay.
documents.
So, yeah, I'm sorry. Is that this thing that I don't think I have a copy of that's labeled respondent supplemental documentation?
Yes.
Okay. Do we have a copy of that documentation in the room tonight?
I believe it was 103 pages. We don't. It's available online.
Okay. In the future, we should, and that would be good. But I will, is to the petitioner, if that was supplemental material that you submitted, is that just sort of more of the same?
That was kind of additional information because there was certain things that weren't included in the initial complaint.
Okay.
So those are additional things that kind of
it just bulks out the
documented these certain aspects of the complaint.
Fair enough. Okay. So let me relate a couple of things and ask a question or two as briefly as I can. So we have on the record the 1993 lease and management agreement. Old news to me, but it's nice to be reminded. There's a provision in there that I think you blew up on a separate page, whatever it was, 26.1 or something, providing for the Joint Zoo Committee. So everyone understands that at the same time as the Sunshine Ordinance was being drafted, the city was entering into negotiations with the Zoo Society to take over operation of the zoo, and there was concern that by contracting it out in this way, that all of the sunshine protections that applied to the zoo as an operation under Rec Park might be lost. And so there was a specific provision included in this agreement that created the Joint Zoo Committee, required it to meet 11 times a year, and subjected both the Joint Zoo Committee and the operations of the zoo under the Zoo Society to the Sunshine Ordinance. It was a very specific and unusual carve out, because surprise, 30 years ago, there was concern about the zoo. So it's not like shocking. That's new. Okay. So on the meeting provisions, because this complaint is primarily about the meetings of the Joint Zoo Committee.
Only about the meetings of the Joint Zoo Committee.
So I'm not sure how much I want to get into the anti-zoo activists description in the minutes. I mean, the minutes have an adjournment time. They don't even have the time that the body convened, whatever. I'm not sure I want to get too far into the minutes as to this preclusion of recording. Mr. Barker, you were at the subject meeting down the hall around the corner?
Correct.
Okay. And so you have said in writing and can confirm that the media member of the public were prohibited, restricted from recording in the absence of a reasonable finding by the body that such recording would, obstruct the proceedings. There was none of that. It was just, we don't want you to tape this.
Yeah, it was Channel 7 said she was at the very back of the room recording, and they said, you need to stop recording. And she stopped recording. And I said, she went out and talked to her editor, her assignment editor, and they said, that's not okay, keep recording. So they came back in and started recording. And then that happened again in December when somebody at the meeting started recording, and they essentially Kat told them to stop recording. I have since in this latest meeting, is it January? Has it already been January? Yeah, January meeting. I submitted the specific information about recording, and they didn't stop anyone from recording in the latest meeting. But there's still an issue.
Okay. And then can you just relate, in case I missed it, on the 67.15 bit, who and how was someone prevented from making public comment on an agenda or a non-agenda item?
So there's kind of an ongoing issue. Basically, this meeting is an hour long and happens right before the Parks and Rec Commission meeting. Okay. And essentially, it's kind of like, from my perspective, because I've been to plenty of different government meetings, this meeting of all meetings I've experienced is like off the rails because the commissioners kind of pick and choose the rules around what happens. Oh, this person gets 2 minutes. This person, we're running out of time. This person gets 1 minute. So it varies greatly, and I don't know all the laws, but in some meetings it turns into this back and forth where like the zoo board members can like have like their opinions about comments from people. So it's really just, it's kind of like a Wild West in this meeting. It's really kind of out of this world. But the kind of the crux of it is that when there's like a limited time, they just like cut people off and don't allow. They either like change the timing of how people can speak, or they just like stop people from being able to speak. And oftentimes, and I don't know if this is an issue, when public comment begins, most of the zoo staff walk out. Most like the zoo director just walks out of the meeting. It is a joint zoo committee that it's like a split between Parks and Rec and the zoo staff, and they like the staff will just walk out. And it's incredibly challenging. Like this is probably out of scope with under your jurisdiction, but I've been like verbally attacked and cornered by zoo docents after this meeting in the hallway, and I'm somebody who's just speaking the truth, sharing information from former and current staff members, speaking up for animals. And the aggression, the hissing in this meeting, it's really something.
You answered my questions. Thank you.
Okay, any other questions? Okay, you can have a final rebuttal statement. I mean, 3 minutes if you want it.
Yeah, I think that I've shared everything about this meeting. I think from my perspective, I am really concerned that the zoo and the joint zoo meeting have refused to show up to this meeting. They're not taking the laws in San Francisco seriously. They're not taking your body seriously. And this is really concerning to me. And it points to the larger issue that both the Zoological Society in San Francisco and what is supposed to be an oversight committee for the zoo feel like they're above the laws and don't respect folks like me who are just trying to trying to understand what's happening and communicate real issues that is impacting the city, is impacting the animals, has dramatically impacted the staff at the zoo. It's really a situation like if you just go and read information about the San Francisco Zoo in the Chronicle, that is just the tip of the iceberg that is happening right now. The more I gain and understand what's happening there, like there needs to be some accountability. And I hope this body can actually do something to inch towards that accountability.
Okay, thank you.
Thank you.
Thanks.
Okay, how do we want to proceed on this one? Member Schmidt and then Member Kumar.
I'm sorry, I just formulated a question that should have happened earlier.
Okay.
To Mr. Barker, under 67.3 of the Sunshine Ordinance, I just wondered if you're of the opinion, one way or another, that this is a policy body or a passive meeting body. Do you have any idea? Are those categories that you're familiar with? And do you feel like this joint committee fits within one of those categories?
I don't know enough information about like that to answer. I know that it was part of the lease agreement when the city handed over management to the zoo, that is part of the lease agreement. And that's all I know.
Thank you.
Yeah.
Thank you.
Yeah.
Member Kumar and then Vice Chair Stein.
So when I was going through the documents for this case, it sort of, for me, it seems like it would have been great if the SF Joint Zoo Committee was here. But what I basically understand is it's a terminology matter more than somebody not taking the minutes properly. Now, I don't know. I have a lot of questions for the department. It could be that they're understaffed. It could be they maybe misheard something, or I'm not taking their side, but I'm saying that there are a lot of possibilities here. So my suggestion would be to probably hear this matter again once we have the committee, because I would love to know what went wrong in that meeting and how they ended up making mistakes in taking the minutes. Doesn't seem like they didn't want to take the minutes. It just seems like the terminologies they used were incorrect and impolite. So my suggestion would be to just hear this matter after the committee joins the meeting.
Vice Chair Stein, go ahead.
Yeah, I was going to say, aside from hearing Member Pilpel's explanation of why this lease agreement was written in a certain way, I was pretty convinced in reading the lease agreement, and I didn't have this document at the time that we heard this in committee, that in fact, I think both the SFCS, as well as the Joint Committee, I would consider them to be under the Sunshine Ordinance jurisdiction. The SFZS, it's specifically mentioned in the lease as needing to follow the local laws around public information. I forget what section that was under, but I think it's section 16 or something. And so for that reason, I think they're included. And then when you look at the ordinance, you know, who gets included under our jurisdiction is any advisory board, commission, committee, or body created by any initiative of a policy body. Well, clearly that Joint Zoo Committee is created by the initiative of two bodies that fall under the Sunshine Ordinance. Or any standing committee of a policy body, irrespective of its composition. They also call themselves a standing committee. And then any advisory board, commission, committee, or council created by federal, state, or local grant whose members are appointed by city officials, employees, or agents. And I think they qualify under both, under section 4, 5, and 7 of who counts as a policy body under the Sunshine Ordinance, as well as it being specifically mentioned in this lease agreement. So I'm pretty convinced that they are under our jurisdiction. And then I do think the petitioner did a pretty good job of talking about their concerns and correlating it to specific recordings of what happened during meetings. And I'm pretty convinced, you know, you hear this body say, okay, you can have 2 minutes. Okay, well, you can maybe have 1 minute because we're trying to wrap this up, and, you know, definitely giving people different times. We hear on 2 instances them telling people, or I think maybe even 3 instances, them telling people that you can't take any video recordings here if you don't have prior permission. I'm trying to find where the other one was. You do hear interruptions. I'm a little bit more uncertain just based on the recordings that I've heard about how severe those interruptions are. I mean, people get interrupted, but you also hear, I think, a chair of the committee saying, like, you know, sort of admonishing someone for interrupting as well from that committee. So I'm just not sure about that. And then even though I do understand and see the petitioner's point that some of the way that things are described in the minutes seem biased, I think you can also maybe attribute that to, okay, this committee, I mean, in a way it's descriptive too. This committee is looking at it and using these biased terms to look at it. And maybe you want to know that. I don't know. And I'm also not sure how pervasive that bias is. But on the issue of people being interrupted, differential time being given, and no video recordings being allowed, I think there's evidence for that in this packet.
Thank you, Vice Chair Stein.
I think everything Vice Chair Stein said, plus not sending a knowledgeable representative to now 2 meetings in a row.
Just a quick question.
Yeah, go ahead.
Does this board have experience with the SF Zoo previously? Like, is this typical?
I was going to speak to that. It's a great question. Because that covers a lot of that.
Yes.
Quickly about the not sending someone. Strangely enough, that's written to 6721 about sending a knowledgeable representative. That's not, which is the public records part. So maybe the next we can do it, but it's strangely enough not written.
It doesn't apply to meetings,
which I think is another thing that needs to be fixed.
Okay, I rescind that.
So I think that's something maybe for the next one, since the next one that seems to be a 6721, but I don't think we really have much here. Now,
No, go ahead.
did you want to?
Oh, no, I still wanted my question answered.
Okay.
Can I address it when I come on?
Okay, then hang on. So Mr. Barker came before us, I think maybe Member LaHood, Member Highland, me and Member Wolf were on the task force at the time. And we went through this, we looked at the contract, and we made several findings that absolutely this applied across the board, everything that Vice Chair Stein just said. The zoo did send someone at the time. It was, I forget his name, but I think it was the vice chairman or something of the zoo. And was very insistent essentially that the Sunshine Order doesn't apply to them. They have nothing to do with it. And he made pretty much clear at the time that they were not going to follow any of our orders. So it does not surprise me at all based on the communications we had with them 5-ish, maybe 6 years ago, that they don't show up because they think that it doesn't apply to them. But nonetheless, we had, I don't want to say for certain, but I think it was unanimous vote of the members that we had jurisdiction over them all.
The zoo or the zoo commission?
I don't remember exactly who's
zoo.
It was the zoo. And this is the thing that's interesting about this that's a little bit different is that this is a joint committee.
Yeah, this was
and
more
with
so.
Meetings in City Hall,
Yeah.
where you absolutely have a right to record.
Yeah, that's a good point. So I think if there was any question on the other question, which was just the zoo, which we did find jurisdiction, this one's even more closely related to the Sunshine Ordinance than the one we even had findings on before. That's I don't remember how I remember the hood you were here for those. That meet your recollection of what?
Exactly. We determined that because of funding they receive, et cetera, they were in our jurisdiction. We had the right to rule.
Yeah, and the contract was
the contract and everything else. So that begs the question. Eventually, is this a 6734 down the road if this keeps coming up? Because
right, if I recall last time, what we tried to do is we tried to get someone from Park and Rec to show up, and I think we wrote them letters and said, because there's a contract between Park and Rec and the Zoological Society or whatever it was, that someone from Park and Rec needs to take
the
lead on this. And I think we may have even tried to get a response from, I think it was Phil Ginsburg, right? And he never showed up, and that kind of was the end of it. And I think we may have written something to the board saying that, take a close look at this contract because they're not following through on it.
Right. So I think, thinking ahead, if we go down those steps, we definitely need to pull them in for due notice.
Yeah.
To be able to.
Right. Because it was hard when it was the zoo people who showed up because they're like, we're zoo employees. It's like, well, then fine. Then someone from the city has to come and defend this because the city obviously contracted with them.
Does anyone here remember if the city attorneys, our city attorneys, our people, like this guy right over here, if they've ever given any kind of opinion on what's the extent of our ability to make decisions, make orders, et cetera, with regard to the zoo?
Yes, there is.
Okay, so there was city attorney
June 4th, 2019, by DCA Mark Price Wolf. And they provides a whole section on jurisdiction.
Do you recall the conclusions?
Never made it. They don't make conclusions in these. They basically pose questions for us.
Okay. No conclusions. Got it. Okay. Thank you.
But it infers conclusions with the evidence that he found. I'd have to read it again. It's a little long.
Let me on this side. We'll go back to this side. So, Member Kumar and the Vice Chair Stein, were you in the queue again? Oh, I'm sorry. Okay, go ahead, members.
I just wanted to say that the zoo stand is very clear, but we sort of don't know the stand of the SF Joint Zoo Committee because they're not here. We don't even know. I mean, have we ever had a representative from the San Francisco Joint Zoo Committee?
So
at one of our meetings?
Probably not. I don't recall anyone from that, but our administrator has a contact person for every department. If they choose not to send someone, that's on them. We don't typically delay decisions because they decide to ignore our emails.
I understand, but I also want us to consider the possibility that if they have never attended a meeting of the task force, they might not be aware that they fall under the purview of the Sunshine Ordinance. That can be a possibility. It could be a new hire or somebody who's not aware of the ordinance. So I just want to put that out there that since they're not here and there is a possibility they may not be aware that they fall under the purview, so it might be a good idea to just check with them as to whether they even know that they're violating the Sunshine Ordinance.
Okay. Several things, and I will try not to repeat. So yes, section 16, starting on page 65 of the packet, subsection 16.1, point 2, point 3, point 4, discuss public access and open government provisions, generally records and information, the Joint Zoo Committee, and designated positions on the board. To recap briefly some of the history that you may or may not know, I'm trying to remember back. Saul Kitchener was the longtime director of the zoo, Manuel Molinado, Tanya Peterson. There may have been a couple of acting people in between. Jim Lazarus, who's fairly well known and was a deputy city attorney, was the chief operating officer or whatever they called it at the zoo for a while, was on and chair of the Recreation and Park Commission. Tanya Peterson is the current director of the Zoo Society. She's also a lawyer, by the way. There was a guy named John Mann with 2 N's who was the chief operating officer at one point. There was a complaint that was brought to this task force during the Manuel Molinado days after he was terminated. His wife was seeking records, and there was back and forth about the status of the zoo under the agreement. And yes, there have been, people and animal controversies as well throughout, but, there are a lot of characters in this thing. I remember going to a Joint Zoo Committee meeting at the zoo on a Saturday afternoon sometime in the 90s. So they have met at the zoo. They used to meet at the lodge. They now meet here, apparently. So there's been some movement in that regard. I do believe, and this was not, yes, this agreement is between the city and the Zoo Society by and through the Rec Park Department, but it was authorized by a resolution of the Board of Supervisors. I believe a reso, not an ordinance, but I think there was pretty clear understanding about how this would apply 30 plus years ago up to today, and that continues. And in my view, that makes the Joint Zoo Committee, although it shall be an advisory committee, that's fine, but it's still a committee of the Recreation and Park Commission and the Zoological Society, and as such is a policy body under the Sunshine Ordinance, not a passive meeting body, and is subject to 67.15 and 16. And what we heard, if we believe that testimony, I think leads to a violation of 67.15 and 16 as to their meetings. Going forward, I think they have options if they believe that there's more than an hour's worth of work to do to start earlier than 9 a.m. If they've got a 10 a.m. commission meeting, they could start at 8:30 and whatever. They could push their commission meeting, or they could meet on another day. There's no reason why they need to meet back to back the way they're currently doing it. That's their choice. But to suggest that they can do all of their business in an hour, given the amount of concern about the zoo, may be unrealistic. Anyway, I hope I addressed some of the concerns. Member Sugarman, did I catch? Okay.
I concur.
Sounds like we're ready for a motion.
So I'm definitely with 15 and 16 as to this one.
Is it 15 and 16 or 14 and 15?
I apologize. Was it the wrong site?
14 is filming, 15 is public testimony.
Like I said,
14 minutes.
Right. 14 and 15. I'm not convinced about the minutes because I'm not sure that we need to get that far into how they characterize their minutes. But yeah, 14 and 15. Sorry. Thanks.
Member Schmidt?
Yeah, the question to members Pilpel and Stein. There's been mention of whether this is a policy body, Member Stein enumerated, let's see, 67, 4, 5, and 7. And I wonder which would be your strongest argument on whether this fits, because there's just, I'm just trying to like look at this. It's almost like fitting a square peg into a round hole. Like, which one of these is this thing? Do you think it's equally 4, 5, and 7, Member Stein, or is one stronger to you than the others?
I think it fits under 4, 5, and 7.
Microphone.
I think it fits under 4, 5, and 7. They do sort of try, I think, in that lease agreement to say they're not a policy body, but 4 says any advisory body created by the initiative of a policy body. So I think it's clearly that. I mean, that might be the best one, but I think it's applicable to all 4, 5, and 7.
Okay. And I'm going to ask in a moment of Member Pilpel. Okay. So created by the initiative of a policy body. I'm guessing, because I'm open to like ideas on this. I just want to make sure we sort of talk about it. I guess the idea would be that this joint zoo committee, who is named in this contract, was created by the initiative of a policy body. Now, what would be the initiative and who would the policy body be? Would that be the Board of Supervisors, or was this joint committee created by the, a contract, which is the contract that we're looking at? I'm looking for a good argument on why we would fit into number 4.
Yeah.
Very briefly, we could go look at the bylaws of the Recreation and Park Commission and see if it's specified as a subcommittee of the Rec and Park Commission. 4 and 5 are the strongest. 7 is a maybe, but 3 is pretty clear as well. Created by ordinance or resolution of the Board of Supervisors. I'm telling you, I don't have the file number right now, but there was a 1993 resolution of the Board of Supervisors that authorized the Recreation and Park Commission or Department to enter into this agreement. And my view is that under D3, at a minimum, it's a policy body. And there hasn't been, to my recollection, Member Wolf, tell me if you recall otherwise, I don't think there's been any contesting in the past of whether or not the Joint Zoo Committee was a policy body. Whether or not they showed up is a different question. I don't think anyone's ever said that the Joint Zoo Committee is other than a policy body under the Sunshine Ordinance.
Correct.
Not that I'm,
Okay, thank you. Thank you. And Member Wolf, did you have a thought on this?
Yeah, I did. If I don't know if you have the agreement in front of you.
Yeah, I do.
But in section 16.3, it says the joint, in the middle, it starts, the Joint Zoo Committee shall hold regular public meetings at least 11 times per calendar year to discuss and hear public testimony regarding major policies affecting the zoo, including without limitation, setting of fees, new animal exhibits, animal acquisition and disposition policies, land use, and capital and operating budgets. That's pretty broad. Then it goes on to say it should be an advisory committee and shall not have any legislative authority not specifically granted to it by this agreement. But I agree with Member Pilpel with regards to that if it was a resolution or whether it was an ordinance, that would be considered the initiative of the policy body, which here would be the Board of Supervisors. But I believe that it is a policy body, as Member Stein had well described. And I think we should continue to not only hold it to that measure, but we should also declare it so that it is understood from this body that under sunshine, we consider that body to be a policy body.
All right. Thank you to all of you. I think it's such a close call for me, but I think I'm convinced. Yeah.
So I'd just like to point in the packet, page 44, at the very top of the agreement, because although it is signed by the head of the department, it says this San Francisco Zoo lease and management agreement is made and entered into as of July 1st, 1993, by and between the city and county of San Francisco and municipal corporation acting through its Recreation and Park Commission. So if this is happening under the aegis of the commission, then the commission was responsible for, in part, for creating the joint commission or committee that we're talking about. So I think it does apply.
Excuse me. I'm sorry. I just noticed. Thank you. Page 2, recital E, Board of Supervisors. I was wrong. It wasn't a reso. On X date, September 7th, 93, adopted ordinance number, blah, 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 approving the form and substance of this agreement, blah, 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 blah. Okay. So yes, it went through the commission. There was a lot of discussion at the commission about how to do this, but ultimately the commission didn't have the authority to approve an agreement like this. Only the board had that power under the 1932 charter, and not even by resolution. Today, it might even be by resolution, but at that time, it was adopted by ordinance. So I don't think there's any question that's a D3, but thanks.
Okay, so does someone have a motion?
Oh yeah, that too.
Vice Chair Stein?
Should I take a stab at it?
Yeah, I think you're really close there before.
I'm just wondering how to incorporate this Board of Supervisors. It's like section E of the recitals.
Yep.
Sorry. I wonder if I can say something like this. That I would move that the Joint Zoo Committee and the SF Zoo, if I can do both, are subject to the Sunshine Ordinance under section E of the recitals portion, and section 16 of the San Francisco Zoo Lease and Management Agreement of 1993, and section 67.3D of the Sunshine Ordinance. I would find violations of the Sunshine Ordinance, section 67.7D, that requires that members of city bodies during public meetings make only minimal clarification or questions during public comment periods. Section 67.14A, the right of persons attending open or public meetings to take video and audio recordings of the proceedings. Section 67.15C, applying time limits uniformly to members of the public during public comment periods. And that we request that this is the part I'm wondering about. I would like to request that the petitioner, no, that's not what I want. Violation of 6721E for not sending an authorized representative to the, no?
Can't do that on this one.
That would be for public records.
Oh.
It can't be from open meeting part.
Okay.
Next one, we might be able to do that.
I would like to send this to the CAC for us to be able to get an acknowledgement from the Joint Zoo Committee that they will comply with these sections of the Sunshine Ordinance moving forward, or they will be found in willful violation of the ordinance.
We would accept that, but I'm wondering if it's actually an EOTC thing, because it's about ongoing procedural stuff and maybe education required.
That's a good point. What do you, Chair Highland?
Sure.
Maybe EOT, because yeah, it's not something they can produce it and then it's done, right? It's more of a changing of procedures.
It's a discussion.
Okay. So I would like to put that in because I feel like they've signaled to me that they don't think that we apply. And it really seems clear that we do apply. And I would rather not have it come back as like I want like to just state here that we've kind of thought this through a little bit. So then I would say that it be sent to the EOTC to work with the zoo committee to get an acknowledgement letter or something, that they will comply with these sections of the Sunshine Ordinance moving forward or will be found in willful violation.
So they're on notice.
Yes.
Yeah. And that might involve additional training as warranted, whatever. I'm happy to second that. I think that's a good, comprehensive, powerful motion.
I think if you, Mr. Chair.
Oh, go ahead. I'm sorry.
I think if you were to state that they would be in willful violation, if we're following the ordinance, then it would have to reference a person. Because the body can't be willful, it can't be willful failure. There can't be action against the body. It's an action against a person.
You could finagle that to notice that they may be found in violation, that they need to get with the program.
Well, that's a good point. Actually, that's a shortcoming of the willful violation is that commissioners are actually not covered by willful violation. It can be elected officials and department heads, but not commissioners. Strangely enough, which is one of the problems with it.
As a payment?
Well, if it's under the aegis of Rec and Park, then it's the department head.
Right. It could be Phil Ginsburg if he's still there. But maybe that's
leave that out.
Maybe we leave that out for now.
We can burn that bridge another day.
Yeah, maybe just leave it with the referral to EOT, and then EOT can come back with how. If you guys can, loop in someone who is covered by 6734, then that bolsters that.
Yeah.
Okay, so that was moved by Vice Chair Stein, seconded by Member Pilpel.
I can repeat it if you need it, or I can send it to you. Email it.
Yes, please send it.
Okay, let's go ahead and take public comment on that motion.
Anyone in the room wishing to make public comment, please approach the podium. If you're online.
Hi there, my name is
Just a
Jane
moment.
Tobin. Are you ready?
Just a moment, please. And if you're online and wish to make public comment, press *3 or raise your hand in the app. We have someone at the podium.
Hi, my name is Jane Tobin and I serve on the
Would you-
Joint Zoo Committee.
Hold on just a moment.
What?
Public comment.
So 3 minutes.
Your 3 minutes begins now.
Okay, I serve on the Joint Zoo Committee. However, I'm a non-voting member on the committee. I hold one of the animal welfare seats that there are two that are not well documented in this MOU. What is listed are 3 Rec and Park commissioners and 3 San Francisco Zoological Society board members. So my voice doesn't, I can't take on the responsibility of the changes, but I do have a suggestion. There's a casualness because of where the room is and where we meet, which is room 421. It's a meeting room, right? Rec and Park the Joint Zoo, Rec and Park commissioners have to exit to make it across the hall to a 10 o'clock meeting, which is recorded, which is much like this, a much more public forum, and would, I think, anchor that meeting in a little bit more of the, I guess, spirit of the MOU. So I would recommend that the meeting shift over to room 416 and become recorded there, allow for public comment, which there's timers such as you have to somewhat professionalize it. And that's just my recommendation, having sat on this committee now for 10 years. Okay.
Thank you for your input. And that might be something you want to share with the committee itself. We can't
Right.
move them around, but that's excellent input.
Thank you for hanging out the last 4 hours.
Yes. Okay, do we have additional public comment on this?
Are you ready, Mr. Torres?
Thank you. Hi, good evening. It's a long evening, huh? My name is Michelangelo Torres, and I'm actually the chairperson of the Animal Commission of Animal Control and Welfare. In fact, we have our meetings in here, so a week from tomorrow, I'll be on that side of the podium. Anyways, I just wanted to kind of clarify a couple things that were said and some questions as well. Concerning the concerning the recording of meetings, I wanted to point out that it was video recordings that is at an issue right now. Audio recordings are fine. It's the video recordings that the committee members have stopped people from doing. In addition, I also wanted to kind of give a little bit of clarification concerning public speaking and public comment there and some of the interruptions that are happening. As a commission chairperson and as a commissioner, I know that interruptions do happen sometimes. The difference with these interruptions is that they are done by committee members towards members of the public. So that'd be no different than one of you interrupting me right now and continually, as was heard on the recording. So that's another issue right there. Also, too, as a commissioner, we have an obligation to hear public comment. We've had meetings go on for 4 hours based on public comments that went way beyond what we had anticipated, but still we had them. And we were been advised by our deputy city attorney that we needed to do that. Unfortunately, that is not the case with this committee, where they basically just say it's done with. It's 10 o'clock. We have another meeting to go to. It'll be continued to next meeting. And of course, it's continued to the meeting after that and after that and after that. So I wanted to point out that. The other thing I did want to also mention is concerning the minutes. And one thing that does happen is that committee members will often use public comment period to talk about items that are not on the agenda. In other words, they'll do it in response to a public comment, where one committee member will respond to that, then another committee will, and then they will continue a conversation. And this is documented within the minutes as well. Okay. So anyways, thank you so much. Okay. Again.
Appreciate your feedback.
Mr. Chair.
Yes, Member Wolf.
May I ask that last speaker a couple of questions?
Sure. Do you have a second? I have a member who has some questions for you.
Yes.
So have you been trained or have you read through the Sunshine Ordinance?
Yes, I have. Yes.
Are you familiar with the section around public testimony?
I believe I am. I mean, as far as I believe I have been. I've also been briefed, and we've had a deputy city attorney attend our meetings as well to go over this. I believe I may not be an expert per se, but I think with experience, I think I can answer those questions or can respond to it.
So
Yes.
what concerns me was you're kind of trying to compare our body here at Sunshine Task Force with your body. And when we interrupt a party from speaking, the party that's speaking before us, that's not public comment. That it's part of a hearing process.
No. Member Wolf, no. He was speaking of his experience watching the these joint Zoom meetings, and that the joint Zoom meeting people are being interrupted or doing interrupting during public comment. I see. Okay. I didn't grab your name, but I think he's from the Animal
Control and Welfare
Commission, and he has an interest in that. So he's kind of giving his third account.
I misheard. My apologies. Never mind. Thank you.
Yeah, that was all pertaining to things I witnessed at the committee. And, I came into attending the committee meetings because, as we have a member who sits on a non-voting role, I wanted to be more familiar with what was going on there. Okay, thank you. Sorry for any confusion.
No, it's okay. We appreciate your feedback.
And Mr. Chair, I would just say that if it's needed, yes, training through EOTC, I think would be helpful. If they're interrupting public comment, that would be not a big no-no.
For sure. Okay. I don't see anyone else for public comment. Anyone?
While Pat is looking, I just wanted to thank the two speakers. I may use my Carl Friedman story another time. and appreciate the work of the Commission on Animal Control and Welfare, which for a long time had been an orphan at City Hall, had its own phone and maintained its own, whatever. You've got your own crazy history, Sally Stevens, et cetera. So I appreciate your efforts and thank both of you.
We have no hands raised.
Okay, let's go ahead and move to a vote on that motion then.
On item 8, taking the vote, Member Stein.
Aye.
Member Stein, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Highland.
Aye.
Member Highland, aye. Member Wolf.
Aye.
Member Wolf, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 10 ayes.
She asked me. I didn't hear my name.
I did not. Member Anderson.
Aye.
Member Anderson, aye. Now we have 10 ayes.
Okay.
That's much better.
Okay, let's go ahead and move on to the next item.
More zoo.
I see Mr. Barker still with us. And it doesn't appear that anyone from the zoo has joined us in the last 30 seconds. So,
That is correct.
okay. So essentially same thing. You'll get 5 minutes to make your case.
Item 9, file number 25003. Complaint filed by Justin Barker against San Francisco Zoo for allegedly violating Administrative Code Sunshine Ordinance, Section 67.21 by failing to respond to a public records request in a timely and/or complete manner. On January 21, 2025, the Complaint Committee, moved by Chair Schmidt and seconded by Member Stein, referred the matter to the full task force for consideration of a Section 67.21 violation and additional consideration of whether the task force has jurisdiction.
Okay. Chair Schmidt, want to give us an update?
Yes.
Summary?
Same petitioner, but this is against the Zoological Society, and it involves documents. Request was made a long time ago, July. A long list of categories. I think I got the number 21 of records. Very, very little was produced. I don't know, maybe 1 or 2 pages. I think we recommended finding a violation. The motion, Member Stein made the motion on this one. The respondent also did not appear and is again not appearing. And so 6721 non-appearance would apply here. We do have the zoo maintaining the position, I believe, that they don't need to appear because we wouldn't have jurisdiction over them. I think that analysis is a different one than the committee we just heard about, but that's just a question that is always involved in these cases because it is a private society. Okay, I think that's all I remember starting. Anything else?
No, that's good.
Okay. You'll have 5 minutes, and Pat, if you can let Mr. Barker know when he can begin.
Are you ready? Your 5 minutes begins now.
Thank you. I first I want to acknowledge that I've filed a complaint against the San Francisco Zoo before, and it is incredibly noticeable how quickly I have filed a complaint and it has been heard. It is very noticeable how fast it's moved comparably. So I appreciate that. Excuse me. I'm here to really highlight a long-standing pattern of secrecy and non-compliance by the San Francisco Zoological Society and its CEO, Tanya Peterson, one that violates the law, undermines public trust, and shields zoo leadership from accountability. On July 31st, 2024, I submitted a public records request for critical zoo documents that included the 2022 AZA accreditation report. After a long delay, I received just one single page of what is usually a 35 to 55 page report. And conveniently, that was a glowing review of Ms. Peterson herself. And this is not just bureaucratic inefficiency. It is a clear violation of an evasion of accountability. The city of San Francisco owns the zoo and all of the animals at the zoo, but is run by the Zoological Society. The city pays the Zoological Society $4 million a year to manage the operations. And despite receiving millions in public funding, the Zoological Society is refusing to follow public transparency laws. And the 85-page lease agreement between the city and the Zoological Society is explicit. In section 16.2, it states the zoo must provide public access to information as if it was still city-run. And it also says all information concerning the status of animals must be public under the Public Records Act. And yet, for over 15 years, they refuse to comply. And as it's been mentioned, in 2008, this task force ruled against the Zoological Society in file 08015, finding them in violation of the Sunshine Ordinance. That was Manuel Melindo, who was the zoo director, and the zoo committed to transparency training. In 2019, this task force ruled in file 19048 that the Zoological Society had violated the Sunshine Ordinance, and the response to the zoo that they intended to continue breaking this law, and they continue to break the law. Nothing has changed. Tanya Peterson still runs the zoo, and luckily, what has changed since 2019 is former and current employees have come forward, and I have a much better understanding of what's happening at the zoo, and it is incredibly problematic. The zoo leadership has made it really clear they do not take transparency laws seriously, and they don't take this task force seriously. The fact that they've refused to attend this meeting is deeply concerning. The Board of Supervisors has voted for a BLA audit, and I'm deeply concerned that the Zoological Society is going to do the exact same thing with that BLA audit that they have done with this task force. Not show up, refuse to give records. And I really urge this task force to find the zoo in violation and really move fast, because there are some seriously urgent issues that must come forward. It is very clear that at the zoo, from what my understanding, that there are major issues around corruption and financial mismanagement that needs to be addressed. And the only way to truly address that is if the Zoological Society follows through on these transparency requirements. And really, it's so important that this body makes it clear to Ms. Peterson, who is the director and who has been the one who has led the efforts to shield the public from this information, that transparency is not optional and that it is the law. And these folks, the folks that are running the Zoological Society, feel like they're above the law. And
30 seconds.
And I really hope that this committee can move quick and not give the Zoological Society the benefit of the doubt that they will not show up, that they will continue to violate the laws, and that something needs to happen. There's an ethics violation, and I really hope that this committee can, this task force can, to hold the zoo to account.
Thank you.
Okay, thank you, Mr. Barker. Actually, I have a question for you. So you've obviously been to some of these meetings before. We've kind of gone through this, and you cited a long history. I'm just curious from your standpoint, knowing how this has gone before, what recommendations you may have, at least for what you would like to see us try to do, knowing, like I said, I think you kind of know what we can and can't do to a certain extent. So what do you think might be most effective from your vantage point?
Yeah, in that essentially like the pandemic, I think, kind of messed up the 2019. There wasn't like that finding didn't necessarily like move forward in a way.
Yeah, we were put on hold.
Yeah,
for
things just
months and
happened,
months, and
you
there was
know.
no continuity.
My hope, is there needs to be training around the zoo needs to have training around the Sunshine Ordinance. I really would hope that they can create one person that's dedicated to fulfilling these records. And I really think that this, as this moves forward, that the Ethics Commission needs to hear this case because there's serious ethics violations happening. I think there's like different avenues that can go, but I feel like that is what I would hope would happen. That this is clear ethics violation, and that the zoo really, it doesn't really feel like no matter what this body does, they think that there's any oversight. They just feel like they're above the law, and that is unfortunately the culture at the zoo beyond public records. There's a very toxic culture at the San Francisco Zoological Society, and this is just one little aspect that I hope can be addressed.
Okay, thank you.
So just as I commented at a previous meeting last week or the week before, I don't think that this body, the Sunshine Ordinance Task Force, should get into the back and forth at the police commission about police powers and this whatnot. I don't think we should get in the middle of controversies at the zoo, but I do believe that the issue of what they're subject to is properly before us. So on your request of July 31st, 2024, you had 9 categories of thing. Did you ultimately get responses to some of them, all of them, none of them? Because all we saw was the waiving confidentiality of her performance review, which to me seemed a little off, but I didn't get into all of it. Anyway, were you satisfied ultimately with the records that were produced, even if it wasn't as timely as it might have been?
Absolutely not.
No.
Not satisfied. In fact,
Was that the only thing you got? Was that wave
Yeah, I mean,
thing?
I've been at this since 2008.
No, but be specific to this.
Specific to this,
Okay.
that was the first time the zoo had ever responded to any records request,
Okay.
and it was one single piece of paper that was a glowing review of Tanya Peterson.
Okay.
And that's just of like a 30, like I mentioned, a 35 to 55 page document. And what I've learned is even her internal staff haven't seen that AZA report. Like
Okay.
there's secrecy within the organization too. So I am not satisfied with how the zoo responds to records.
Okay, so we'll come back to that. And you're aware that Ms. Peterson used to serve on a city board or commission. I believe Mr. Leung, who it looks like is now the deputy director, used to work for the city and is now on a city board or commission. So it's not like they're unfamiliar with the applicable laws. Does that sound about right?
They should be very familiar with the laws.
Okay.
She's a lawyer. Tanya Peterson is a lawyer.
You answered my questions. We'll come back in discussion. Thanks.
Any other questions? Seen any? Okay. Can I have your closing remarks, 3 minutes.
Thank you for hearing this. This is incredibly important. This advocacy for improving the San Francisco Zoo has been underway since 2008 when the tigers escaped and died in a hail of gunfire. The zoo has gotten worse and worse since then, and it's largely this mismanagement. And really, like as I mentioned, luckily, the the former and current staff have been brave enough to come forward. That's the only way that Chronicle has been able to expose what's happening. But we're really, I think, a long ways away from truly understanding the full breadth of the problem at the zoo. And largely, I think what really needs to be understood, particularly through these records requests, is what's happening with the money at the zoo. The fact that millions of dollars have come into the zoo and very little has happened through the exhibits, we have a really serious issue around the finances and where money has gone. And Tanya Peterson has specifically made $5 million since she became the interim zoo director and hasn't left as at a nonprofit in San Francisco. $5 million. And it's just unbelievable what that has gotten the city, a totally dysfunctional and failing zoo. And I know that's not the point of this conversation, but it is really important that we move. It's important to me as an activist standing up for animals and standing up for the current employees at the zoo and standing up for the city of San Francisco that we move quick, and then I'm able and the media is able to better understand the extent of the dysfunction within San Francisco Zoological Society. So action can be taken to truly make a real change at San Francisco Zoo and help the city and the citizens understand that, hey, it's time for change, and records is hopefully the way to kind of inch towards that.
Thank you.
Thanks.
Okay. How do we want to proceed on this one?
Mr. Chair?
Yep. Member Wolf and then Vice Chair Stein.
Yeah, so I believe in some of the previous decisions and determinations the task force has had around SF Zoo, is that we found that it was within the 12L jurisdiction, which would require disclosure of financial records, at least having at least 2 meetings per year, open to the public of its own board of directors, under any contract over $250,000 with the city. That's the first thing. Second thing is, I think we've heard a lot about this organization over the years, enough that I think it's time that we notify the board of supervisors about it. I think there's some, if things are as serious as what's being presented, then I think it's worthwhile for them to at least know that it came across our desk and it raises at least the yellow flag, enough for them to have a gander at it. I'll stop there.
Okay, thank you, Member Wolf. Vice Chair Stein.
Yeah, I mean, I can take a stab at a resolution.
Use the mic.
I take a stab at a movement.
Sure.
I would move that the San Francisco Zoological Society is subject to the Sunshine Ordinance under the SF Zoo Lease and Management Agreement of 1993, Section E of the Recital Section, and Section 16.2, and Section 67.3D of the Sunshine Ordinance. I would move to find a violation of 67.21B for not responding to a public records request in a complete or timely manner, and 67.21E for not sending an authorized representative to the task force hearing. I would also move that we forward this complaint to the EOTC for follow-up and training, and that the respondent should turn over requested records, or the SOTF will find them in willful violation, and this, I guess I mean Tanya Peterson, in willful violation of Section 67, a violation of Section 67.34, in willful violation of the Sunshine Ordinance. We also, presuming that it's not turned over, we would forward this to the complaint or forward this complaint to the Ethics Commission and to the Board of Supervisors. And that the EOTC, I guess I already have that, will work with the SF Zoological Society to achieve compliance with the Sunshine Ordinance. Get rid of that earlier mentioning of the EOTC.
Member Pippo?
I'm prepared to second, but Vice Chair Stein, the bit where you said near the end that we would or will, could we soften that a little to would consider or may, so that we're not saying that we're absolutely going to refer it to ethics?
Okay, may find Tanya Peterson willful violation of the Sunshine Ordinance under.
Yeah, I'm not sure that we can, and I don't want to prejudge.
Yeah, I say may find instead of will.
The same concept as previously that we're putting them on notice. Get with the program.
Before we didn't mention the.
We didn't mention it because it was a public.
Is it appropriate? We typically have not.
Well, that's why I'm thinking about how to soften that a little.
Typically, we haven't had, and we can do whatever we want, but we typically haven't put that type of language in the initial motion. We typically send it to the committee. The committee says they're not playing along. They're not doing what you guys asked. Refer it back with the suggestion that we do a willful violation. It seems to me be prejudging how it might go in committee. I don't have high expectations, but nonetheless.
What about instead of saying that, then putting some kind of time frame in for seeing this compliance?
Yeah, well, I think that's totally.
So that this could be fast tracked if nothing happens.
Yeah.
By when's the next meeting? Was it we just talked about? Was it March 18th?
In fact, it is. Yeah.
Was it March 18th?
Well, should we just say turnover? They should turn over requested records within 5 days, because that's what that's what the Sunshine Ordinance says. Within 5 days. Okay.
Calendar days?
Sure.
That was
Either.
a question. I'm sorry, 5 calendar days?
I think that's what it means. Yeah. Okay, so I can read this one more time.
And can you also provide it in writing?
What?
Yes, you will email it to.
Yes, I'm about to email it. So Member Stein moves and Member Pilpel seconds that the San Francisco Zoological Society is subject to the Sunshine Ordinance under the SF Zoo Lease and Management Agreement of 1993, Section E of the recitals section and Section 16.2, and under Section 67.3D of the Sunshine Ordinance. We move to find violation of 67.21B for not responding to a public records request in a complete or timely manner, and 67.21E for not sending an authorized representative to the task force hearing. The SF Zoological Society should turn over requested records within 5 calendar days and work with the EOTC committee to achieve compliance with the Sunshine Ordinance.
Yeah, I still think I'm with that. I'm a little nervous about the 67.3 reference because that's about meetings, and I think that gets the Joint Zoo Committee in as a policy body, but I'm not sure that gets to where you need to be on records. I think it's the 16.2 reference and recital.
I can take that out.
Okay. I mean, I'm still with the rest of it.
That's a good point. It's a different respondent.
And it's not really needed because it's very clear under their own lease agreement that this law applies to them.
Yeah.
Okay, so retract that last piece and I'm going to send it to you right now. Okay. Peterson.
Okay. Any discussion amongst the members on that? Member Schmidt?
I just want to put my explanation on record, which is I think
Microphone.
I think I'm going to vote no. I don't know if I'm convinced on jurisdiction on this. I sure wish I could be, but the 67.3, I was thinking that wasn't working for me. And Member Wolf mentioned that in the past there was a reliance on 12L for jurisdiction. And I don't know if 12L is a way that we can impose a 67.21 penalty. I understand that the argument for jurisdiction is that the Zoological Society made an agreement with the city. They have a contract. They said they would do certain things. I guess I look at two different examples recently. One was the COFAM, which was a private nonprofit corporation, and then the Castro CBD, which was a private nonprofit corporation. And I don't know if I can put right now Zoological Society on the other side of the line here and say that it's subject with those two or not. So I'll probably be the only dissent, and I'm fine with that, but that's my explanation.
Member Sugarman, then Member Wolf.
I was just going to say that I'm glad that you brought that up because I've been thinking about it this whole time. And I wanted to ask if anyone had reviewed just the lease agreement, because to me, the part that I reviewed tonight was about the joint committee, and it named both the Zoological Society. And the Zoological Society was named, but it wasn't like in the jurisdiction question, it's like, well, how much does that obligate the Zoological Society to release in terms of this information? That's the part that I don't know. Like, what's the obligation?
Can I?
Hang on, I'm going to jump in, then I'm going to do Member Wolf, then I'm going to do you. Just to answer a couple things. When I was on the task force, we did not do 12L. That may have been another one that Member Wolf. But I remember specifically voting that the full Sunshine Ordinance applied, and it was specifically on this part of 16.2 under public access to records and information. It says the San Francisco Zoological Society shall provide public access to information concerning the operation of the zoo to the same extent that such information would have been available to the public pursuant to local ordinances if the department had continued to operate the zoo. So in that regard, that means the local ordinance, in this means the Sunshine Ordinance, and the department prior to this was Rec and Park operating the zoo. So prior to this, all these things would have been under the Sunshine Ordinance through Rec and Park. And so my understanding through 16.2 is that that obligation transferred over to the zoo, and that was a specific part of this contract that's different than the other things you mentioned, Member Schmidt, where there was not such an explicit reference in a contract. Where this, they actually called that out, called out the local ordinance, called out how public information used to be accessible and how it should still therefore be.
Thank you. That answers my question.
Let me get Member Wolf, Member Pelpo, and then back to Member.
Okay, so first, my reference to 12L on this was only in the memorandum from legal counsel at the time. And this was in 2019, September, the order of termination of September 20th, 2019, where the task force found by those present unanimously that it held the zoo in violation of 6721, 6727, Government Code 6253, and California Business and Professions Code 4857. I don't know how that made that in, but that was the motion, and that was what was that was approved by the task force.
Remember, if I can actually answer that real fast.
Go ahead.
Business profession. They made a claim back then that the medical records being sought were somehow medical records protected by some business and profession code as far as veterinary records and undisclosed.
It's like patient privacy.
Patient privacy for animals. That's what that was.
Oh, I got it. Yeah. Okay.
I remember that discussion.
Like I'm going to get their credit card number or something. Right? Okay. So,
go ahead.
So the thing is the task force did not adhere to the 12L advice and claimed it then to be a policy body. So I think it's worthwhile to stand with the precedent that the task force had made at that time. Because also in the section of the memorandum, besides 12L, it's under a section called applicable statutory sections. DCA Wolf included Section 12L and Section 67 of the admin code, which is the ordinance. So it's not without saying.
Okay. Member Pilpel, then Vice Chair Stein.
So I was going to relate to Chair Schmidt, member, whatever, Dean, the 16.2 reference, because I think as Chair Yankee indicated, that very much, I think, puts them under the ordinance as relates to records in the same manner pursuant to local ordinances as if the department had continued to operate the zoo in the same manner as it did prior to the date of this agreement. So I believe that it's pretty clear, so I wanted to give you some comfort with that. If the request from Mr. Barker, still remember Mr. Barker out there after all this, if his request had to do with donors to the Zoo Society and donor appreciation and all that, they might have an argument that that's beyond the scope and blah, blah, blah. But as I read these 9 items, they're very much about the facilities, the animals, care and housing, pharmaceutical drugs, loans, paperwork, Ms. Peterson would be in a better place, the zoo would be in a better place to respond point by point. And if they have things that they don't want to release for whatever reason, they should cite chapter and verse as to why not, in the same manner as if Rec Park were operating it, or in the same manner as any other city department. That's the point, to just say, here's the only recent glowing recommendation. That's not what you were asking for. So I think that's the point, and that's where we get to here. And I appreciate that these are joined and sent to EOT. The scope of who needs to get trained and what and how we can sort out, but somebody needs to, get more with the program out there. Maybe it's the salt air and the old pool there that's now the parking lot, whatever. Something's going on, and we got to deal with that. By the way, to Mr. Barker, if you could dig up the 2008 and 2019 actions of the task force, if you're able to find those orders and include that in a future packet, that might help us to nail that down. I'm pretty sure that I was here on the 2008 one, for example. Thanks.
Vice Chair Stein.
Yeah, I just wanted to say I share the same reading really of 16.2 as Chair Yankee. It also does, in addition to mentioning that they should be providing public access to information in accord with local ordinances, it also mentions specifically they should be providing in relationship to the California Public Records Act, which they clearly are not doing as well. And, when we've had these cases that have involved these public-private partnerships where nobody specifies the status, to me, that's what we get with the arts.
The museums.
And, some of those community groups and all of that. But here, someone's taken the trouble to specify it. And I think this is exactly what we should be doing with public-private partnerships. And that's why I would write this movement or motion. Yeah.
Okay. Public comment? Did we do that yet?
Not yet.
Okay. Public comment on this item. Or motion, rather.
Please.
Anyone wishing to make public comment, please approach the podium, or if you're in the online community, raise your hand in the app or press *3. We have no one approaching the podium, no speakers in the queue.
Okay.
Mr. Chair.
Go ahead, Member Wolf.
Yeah, I recall also in that 2019 hearing that the respondent also claimed that since the agreement predated Sunshine, that that Sunshine doesn't apply to the Zoological Society at all.
Wasn't there a version of the Sunshine Ordinance in 93?
It was, if you look at it, they were both running at about the same time. So I just looked into that. The ordinance was approved August 18th, and the lease and management agreement was approved like 3 weeks later in September. But
it would have been in effect.
hold on. But again, if you go back to your read of 16.2, pursuant to local ordinances, as if the department had continued to operate the zoo in the same manner as it did. So if Rec Park were operating it to this day, somebody would be subject. I don't care who the player is. Somebody would have to cough up the records, period. And that's how you get there, I think. I think I may have also promised just a 30-second Carl Friedman story. He did tell me that the problems in animal care and control and at the zoo were largely not caused by the four-legged animals. It was always the two-legged animals that caused problems. That's what I got from Carl. Wonderful man.
Okay, I think we're ready for our vote now.
Taking the vote on item 9. Vice Chair Stein.
Aye.
Vice Chair Stein, aye. Member Pilpel.
Aye.
Member Pilpel, aye. Member Schmidt.
Nay.
Member Schmidt, no. Member LaHood.
Aye.
Member LaHood, aye. Member Sugarman.
Aye.
Member Sugarman, aye. Member Kumar.
Aye.
Member Kumar, aye. Member Anderson.
Aye.
Member Anderson, aye. Member Highland.
Aye.
Member Highland, aye. Member Wolf.
Aye.
Member Wolf, aye. Chair Yankee.
Aye.
Chair Yankee, aye. 1 no, 9 ayes.
Okay, that motion passes. Thank you, Mr. Barker. Thank you to the members of the public who stayed with us this long. We appreciate it. Okay, let's move on to item number 10.
Item number 10, hearing on Sunshine Ordinance amendments, discussion regarding potential amendments to the Sunshine Ordinance and the related work of the Compliance and Amendments Committee.
So I'm just going to keep this as a standing item. Like
Yes.
that. If you have anything, we can do it. If not, we just move on.
I would like to give an update at our next meeting. We continue to review the ordinance and welcome any input or feedback from members of the task force and members of the public. If you look at our Compliance and Amendments Committee agenda items, you'll be able to follow along and see where we are with our review of the ordinance.
Vice Chair Stein?
I just want to make one little input. Maybe I've already made it. I can't remember.
That's okay,
But
please.
it's just based on what we were talking about earlier. I just want to remind people that in the current ordinance, it talks about sending an authorized representative, not a knowledgeable representative. And I've had
yes.
from city bodies tell me we don't have to send a knowledgeable representative. We just have to send a representative. So it might be worth looking at that language a little bit in any.
That's a good point. Thank you.
Yep. And the two things I had written down, I've kind of been doing this as we go along and kind of run into problems with things that are, one, the thing we ran into were 6721E, where people have to actually attend our hearing only applies to public records and not to open meetings things. I think that needs to be fixed so that it's clear they need to show up for any of these. And then the other thing that we got into was that commissioners are actually not included in individuals who can be found in willful violation. I think that seems to be somewhat troublesome. If the zoo, when we educate them, they say, I get it, but I'm still not going to follow it. We still can't say it was willful, even if they outright admit it, because they're not included in 6734.
And you think they should be?
I would think that they should be included if it's including, currently I think it's elected officials and department heads and maybe managers, it says.
Yeah, and managers.
Yeah. The commissioners, for some reason, are excluded, seems like an oversight to me.
I have both of those and fixes underway. Good. Can I just add? One of the things that we discussed at the tail end, I have a suggestion pending to send an early memo to department heads saying that at some point we're going to do outreach to them and all kinds of folks, but some of the specific technical areas, we wanted to get their early input on the labor and employment provisions, the privacy provisions, that blah, blah, blah. So if there are things that their staff say, that may have made sense 20 or 30 years ago, not happening anymore, it would be good to hear about that sooner rather than later. So we're working on that.
Okay, this was just a discussion item, so no action. I don't know if there's anyone still online.
We have one person online. If you'd like to make public comment, please raise your hand in the app or press *3. No hands raised.
Okay, we'll close public comment and move on to the next item.
Item 11, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Okay, anyone have anything for this item? Member Popa?
Some brief items. I made reference to some of the work I'm doing for both of the committees. There are things underway. Just a quick question. Did we get information on the mayor's new sunshine compliance person? Do we know yet?
I don't have that. No.
Still don't know. Okay.
We do.
Nope.
Maybe.
There,
No, maybe Pat knows.
there is an email address that is available. It's a general email address
Okay.
for parties to respond to. I looked online. It came up in an AI search, but I do not find the email listed on their website yet, and I have to contact the office and find
Okay.
out if it's actually on the website and I'm overlooking it.
I haven't found it yet. Anyway, it would be nice to know who their person is. It's not Hank anymore. So,
Wasn't there a person, Ms. Peterson, who I know that we did just get something against the mayor's office?
Yes, that's been provided to me as a courtesy copy.
That, it's not a complaint but there's a number attached to it.
An email address?
No, there was the one that from, I don't want to,
Joe.
yeah, about the text messages.
Blank, yeah. You
Yes,
had
but I
sent that
believe
over.
We sent it to an email address over at the mayor's office.
Yes, but I believe it was a CC. It was a courtesy copy?
Okay, yeah.
Oh, okay, got it.
at some point when we figure out who their new person is, if we could just let people know, that's all. If we don't know yet, we don't know yet. That's cool. Do we have any update from ethics on referrals?
Not that I can speak of.
Okay, maybe news.
I hope.
Okay. It's
that
a
I can
beautiful
speak-
dream.
I hope that I can speak on it. My goal would be to agendize this in some form or fashion on the next agenda. I don't know what that will look like, and I can't say right now.
That's fine, but reason for people to attend future meetings. Okay. The first meeting of the Prop E, too many propositions. The Commission Streamlining Task Force was last Friday. I only found out about it like midday and rearranged my day. Wasn't able to schlep down here. They didn't take remote public comment, but they did meet for an hour and a half, 2 hours. Didn't reference the task force or the ordinance, but did talk about, arranging the deck chairs and whatnot.
We know who's on that?
Yes, in fact, we do, and I'm able to say that. Ed Harrington was appointed in a weird way to represent labor organizations by Aaron Peskin when he was still board president. He was elected chair of the task force. Jean Frazier was appointed by the mayor, I believe, Mayor Lurie, representing the mayor's office. She was previously a deputy city attorney, ran the San Francisco Health Authority, worked in San Mateo County, and now runs the Presidio Trust. She was elected vice chair, representing the three principal offices. Let me think. Sophie Hayward is on behalf of the city administrator. Andrea Bruss, who I guess moved over from the mayor's office to city attorney, is representing the city attorney. And Natasha Mihal is representing the controller. So those are the 5 people on this body. They've got 2 years to do everything, a year to produce a report, et cetera. Anyway, at some point, they will probably get to, if not us as a body, like we can't, whatever, but the implications of sunshine as relates to burdens on appointed bodies in the city. I'm working on a comment.
I think the first stage is actually a budget type of.
There's a budget.
Survey-ish thing going on.
There are several surveys and work products, and they want to hear from the proponents of the measure and Spur and Together SF and whatnot. They're doing their thing. I'm monitoring that. I just wanted people to be aware.
And I just, so everyone knows, I know Angela Calvillo on our behalf, who's the clerk of the board, is also following that and is prepared to advocate for it.
She was present. She was actually very important to the meeting. So that was good. Unless there are any other questions or comments on that, I did want to end tonight on a bit of a sad note. I learned around noon today when I was getting ready to schlep down here that Dennis Richmond passed away, longtime Channel 2 news anchor. Anyone who's been in the Bay Area more than 17 years or grew up here will remember him, although as far as I know, he had nothing specifically to do with Sunshine or public records. I think the connection to the media with this task force has always been strong with SPJ and other organizations and people over the years. And I just think he was really an embodiment of truth and accuracy in media that's needed more than ever now. And so I was hoping we can adjourn our meeting in his memory, which is unusual, but we've done it before. And so I just wanted to appreciate that. He worked at Channel 2 for 40 years from, the year I was born, 1968 to 2008, and anchored the 10 o'clock news for 31 or 32 of those years. And he was good. So anyway, thank you for indulging.
Thank you, Member Pilpel. Anyone else for this item? Okay. Let's see if there's any public comment on this item.
Anyone wishing to make public comment on item 11, please raise your hand in the app or press *3. And we have no one in the room.
Okay.
No one's raised.
Okay. Public comments closed, no action taken. And then let's go ahead and move on to item number 12.
So moved.
In memory of Dennis Richmond.
Item 12. Adjourned at 9:11 p.m.
In honor of Dennis Richmond.
Yes.
In honor of Dennis Richmond.
Okay.
Good night, everyone.
Good night, everyone.
Thank you.
Good night. Mics are off.